help us. I'm just gonna. All right. Good morning, everybody. How's everybody feeling today?
Good morning.
How's everybody feeling today? Great. All right. Welcome to the 33rd annual Nuts and Bolts of Family Law Seminar. A lot of seminars you go to, they tell you we're going to send you those CLEs. We're going to send those things later. Ours, we put it right here. So you have your CLA credits right here. Our first speaker. Oh, and I want to thank not only the sponsors that are here, but I want to thank all of you guys that agreed to take on a case. And if you know any other attorneys that would like to take on a case for the Put Something Back Pro Bono program, we'd really appreciate it. It's something that really, it makes a difference in the community that we live in. Our first speaker is going to be talking about, it's going to be someone speaking about the remarks. Well, these are remarks from the Chief Judge, which will be from Nushin Saifi, the Honorable Nushin Saifi. She has been an attorney for a very, very long time. She worked at the state attorney she did about 75 cases. You did as a public defender. She did 75 trials, and as a judge, I believe that you've been you were appointed in October of 2007, and then she ran unopposed ever since, unopposed. So that's a big. Am I wrong? Yeah, unopposed ever since. So that's a pretty big feat there. So without further ado, I want to turn it over to the Chief Judge.
I like that he memorized some of those facts. That was pretty crafty. So I love being in this room, and I feel like I'm measuring my life by the years that go by, and I'm back here in front of all of you. And those years are going by faster and faster. And I joked with Karen this morning, I feel like this is the Chief Judge Saifi farewell tour. This is going to be my last time addressing you all as the Chief Judge. And I just want to say thank you to the Miami-Dade Bar, to Dade Legal Aid, to Put Something Back, to Karen for putting this together. She came in and she checked with me this morning to make sure I had my remarks, and I was cracking up because I remember 4 years ago, I think you drafted my remarks for me, which I was not used to that happening. And then I think that my remarks have been a sort of a cut and paste of Karen's originals ever since then. But to Karen and to Mark and to Jeffrey and to Stephanie and to everyone at Put Something Back for being so wonderful and for doing this. I want to give a shout out to my friend and colleague, Judge Samantha Ruiz-Cohen, who I'm getting a little nostalgic. 4 years ago, when I became chief, before I started, one of the best decisions I made, I can say 4 years later, still one of the best decisions I made, was appointing Judge Ruiz-Cohen as the administrative judge of the Family Division. I know you all agree with me. So, Judge Ruiz-Cohen to Lizette, who's the director for AOC for the Family Division. Those of you who've heard me, I'm sure I've said it every year here, but I cannot say enough about our incredible staff for the court system. As good as a judge ever is, trust me, there are literally 600 people that support the work of 123 judges, and we're nothing without them, without our AOC, without our GMs, and everybody that supports the work that we do in this division and all the divisions. And to our IT people, it's working this year. I think next year we had some glitches, but not good. And hopefully the Wi-Fi will hold up. So 4 years ago, I was transitioning into the job of Chief Judge. Feels like yesterday, and Karen immediately showed up. I already knew Karen, but she showed up and welcomed me and taught me a ton. And I want to take a minute to just say thank you to Karen for really being just, I don't know, such an incredible champion and supporter. I think I said this recently talking about you. Karen's gifted in that those of you who know her, you all think that you're her favorite. I'm just going to let you know I think I'm her favorite. But she does. She has made me feel incredibly special and just been so attentive and sort of, been the shoulder I've needed, been the support that I've needed all along. And we're so lucky to have you in your role, and the judiciary is certainly very lucky to have you, but I personally feel really, really lucky and blessed to have had you the last few years. And to the family bar at large, I felt incredibly welcomed by all of you 4 years ago. I had not practiced in family. I guess you probably thought I was, and I kind of didn't, so maybe that was a little bit of the tease I gave, but you've all been so wonderful and warm and welcomed me, and you additionally have taught me a lot, and I just feel very blessed to have had this exposure to all of you, to count you as my friends. If you know anything about me, you know that when I make friends, I don't let them go easily, so I am here for you. Even if I'm not chief, I'm not going anywhere, and anything I can do for any of you in the years ahead, please let me know. I'll be across the street. But really, that's been one of the best parts of being chief judge, has been going to different bar organizations, going to different groups of lawyers, and meeting lawyers that were not sort of within the world that I was working in. So I really am going to miss that, but I hope that I can continue doing that and going around and seeing what you all do. So I think you guys have heard my remarks, but part of what I think I always come to when I think about what you all do in pro bono is sort of going back to my own life and thinking about, okay, last year since I've seen you, what are the things that I've had to navigate as a human being? And I've always referred to the fact that, you know, I'm divorced. I went through a divorce. Once you go through a divorce, you know that that's not something that you can do or should do without a lawyer. And that, you know, and mine was easy, and it still was really, really challenging. And I have a father that is 9 years into Alzheimer's disease. Again, something that there's so many people out there who are navigating these issues. I have 3 grown children, and when I say grown, I mean that they're in their 20s and they're technically, legitimately, you know, defined as grown-ups, and yet I've gotten 3 calls this morning. And I will say this, in the last year, since I was with you all, I can say that this is a huge moment for me as a parent, that all 3 kids did their own taxes this year. So for those of you that are here, I know you feel my joy. Like, I wish I could drop the mic, but that's to me, when I go to events and people are talking about how great their kids are doing, to me that was the big thing. Like, my kids did their own taxes, they went on TurboTax. I'm not gonna lie, I printed out last year's returns, hand delivered them to the little bunnies when I saw them in person. One of them still called me on April 14th, while I was at work, forgetting that I have a job, and asked me, Mom, where's my tax return? And I told him that I delivered to him in person in paper, and he was like, Mom, no one does anything in paper these days. Yeah, so that was a fun moment. But they did do their taxes, and they all got refunds, I'm happy to report. But these are the things that we all have to navigate, and I count myself, every time I have to navigate one of these moments, I think to myself, what do you do if you are working in a world where you don't have a job that lets you sit on hold on the phone for, you know, 20 minutes, or you don't have a job where you can take an hour or leave early or take the day off to go and, you know, do what you have to do, your medical appointments, helping your parents navigate, you know, the elderly light stuff, helping, you know, getting through a divorce, parent-child conferences. One of the directors we have working here, who I've gotten to be close with, has a child with autism. And if you are a parent of a child that's going through anything, let alone, you know, a serious diagnosis and having to deal with the school system, how do you do that and navigate the job or the 2 jobs or whatever else you have to do? And in those moments, I count us blessed in this county that we have such a robust practice of pro bono amongst our lawyers. And, you know, thank you all for doing that. I think that these days, as we see and as what's to come, I don't know what's down the pike, but it looks like there's going to be a bigger need than ever. People are going to be hurting worse than ever. I always say, sort of anecdotally, when you walk out the door of the Lawson E. Thomas Courthouse and walk, you know, and grab, you know, a cup of coffee or lunch within 2 blocks of here, you get a sense of what's going on in the real world, just right outside this building. And you get a sense of who's hurting, and you get a sense of how many homeless people are on the street, and what the degree of homelessness, you know, really is, how severe it is. And at those moments, I think, again, like we need to be doing better in taking care of the people around us. Otherwise, you know, that's really, I think, going to be the key towards getting us through whatever we have to get through in the future, is people realizing that it's not just a responsibility to your community. If you serve your community, you really are serving yourself. We're all going to be better off when everyone's better off, and I think that's just a huge part of what we do as lawyers. So thank you for doing all your pro bono. I think that one of the things I've always said, and I think there's some young people here in the room, and I know many of the older lawyers who've done pro bono always are good about telling the younger lawyers, the best experiences you have as a lawyer tend to be your pro bono cases. Those are the ones where you can kind of expand your horizons, do more, and I think that that's just a great way of increasing your experience and your sort of your autonomy on a case. And I will tell you, when you go out in the community That's the stuff that really speaks to the community, are the pro bono cases. And for those of you that ever want to apply to be a judge, that's the stuff that you end up talking about more than sort of the cases that you do in and day out. So I think it's definitely a benefit to lawyers, but I think it's definitely a huge benefit to younger lawyers. And I think just you all being in this room, the networking, the collegiality, that's important too. But more than anything else, I think you're doing a tremendous service to the community, especially at a time when they need it. And I also just want to say on behalf of all the judges, you are doing a tremendous service to the judges when you take a pro bono case. Nothing is worse for a judge when we're all behind the scenes complaining about cases. The one thing that judges complain about more than anything else is dealing with self-represented litigants, SRLs now we call them. But still, the pro se litigants are challenging, and not because, sometimes it's because it's breaking your heart to see them without a lawyer, and sometimes it's because it's making you, claw your eyeballs out while you're listening to what you have to listen to. So to the extent that we get to have lawyers representing people that need it, it's a wonderful thing. It's a wonderful service you're providing to the legal community as well and to the bench. So thank you from the bottom of my heart, but on behalf of all the judges. I just also want to say a very quick congratulations to Jackie Valdospino. I'm glad you're here before I have to leave. But yeah, what a remarkable, you were one of the first people, I think, in the family division that I got to meet early on, and we have a ton of friends in common, but I'm so happy that you're getting this honor. And I knew Mr. Kuttner, so I think that, that this is just a wonderful legacy and a wonderful thing, and I'm glad that this is happening to you. You're very, very deserving. And with that, I'm going to leave you all to have a great day full of CLEs. And yeah, look at this one. That's
Legal Aid.
Look, it looks like an Oscar.
On behalf of the Legal Aid and the courts, our partners, we want to congratulate you and thank you for always remembering to put something back and supporting our program and the seminar.
All right, our next speaker is going to be giving us updates from the family bench. This next speaker used to be an assistant state attorney for 12 years. She handled many, many cases there, including first-degree murder cases. She actually went back, trained prosecutors. Over approximately 300 prosecutors have been trained by this next speaker. And she is the winner of several awards, including the Judge Steve Levine Award for Fairness, Integrity, and Professionalism, and the Hispanic Heritage Judicial Trailblazer Award. This next speaker is the Honorable Samantha Ruiz Cohen.
Hello there. So I want to start off by saying thank you. Thank you for being here, for taking time out of your busy schedule to join us here today. But I have to start off by saying thank you to Dade Legal Aid, to Karen. Talk about professional lawyers and what a wonderful law firm you all are. Thank you for all the work you do. And this event in particular is one of my favorites. I actually, it was my first introduction numerous years ago when I was coming into family from the civil division. So I really love this event. So the family division in the 11th Judicial Circuit is really, truly a family. There's so many things that go behind the scenes. And we cannot function without, for example, our wonderful director, Lisette Sanabria, that if there's anything that's happening behind the scenes, she's there. My incredible J.A. Esther Amador. If you've ever met Esther, if you need something done, if you have any question, and I know I'm throwing more work at her, she will get it done. We have 14 judges, 7 general magistrates, and I can tell you that it's very important to me personally that the entire division approaches each case and treats each family as if, in the same way that they would want their brother or their sister or their mother or their father to be treated. Our cases are raw sometimes. We see folks at usually the most horrible time of their life, the most difficult. But it doesn't have to be horrible. It can be with a judge that is respectful, gives prompt hearings, rules promptly, and treats everyone, again, how you want your sister or brother to be treated. It can make an experience that can be so difficult bearable and help folks be able to get through that experience. And in furtherance of that, for me, it was abundantly clear when I started as the administrative judge in 21, and I want to thank the chief for entrusting me with this responsibility. To make sure, to me it was so clear, the one thing that the parties wanted most, the one thing that the attorneys wanted most, were prompt hearings, to be in front of the judge. Obviously, everything else that I've said already, but that was crucial. And in furtherance of that, one of the things that was, to me, very important was that we create specific guidelines in writing to assist the lawyers to be able to utilize it as a tool with their clients and to make sure that everyone embraced these expectations. So about 2.5 years ago, I asked the INS, the Florida INS, Dade Legal Aid, to send out a poll to the lawyers. When would you like to have that expectation? If you're asking for a 3-hour hearing, when do you think would be reasonable to get it? When are you getting it now? The poll went out. It was submitted anonymously. After that, so I meet with all 14 judges and 7 general magistrates every single month. We have, and I'm sure sometimes they'd rather we not meet every month, but we have a monthly meeting. And so we set out for months to discuss this topic, taking the poll that the lawyers had submitted anonymously. I first asked the judges and the general magistrates to submit when they were setting now. So ask your JA, if a lawyer asks for a 3-hour hearing, an all-day hearing, when are you scheduling right now? We compared it to the polls of the lawyers. And then we went through a series of discussions and monthly meetings as to what was reasonable. When I say reasonable, what I mean is what is fair and what we can reasonably do. I don't know if you've heard that saying, herding judges and general magistrates. It's kind of like herding cats sometimes. So we had a lot of discussions as to that. After months of coming to an agreement as to a consensus, we set out and voted and all agreed on recommended time standards to schedule hearings. I didn't sign the AM yet because I wanted the entire division to go out and, after we had all agreed on it, to go out and do it and see if it needed to be tweaked. And that's exactly what the entire division did. They went out, they set it out to see if this was something that we'd be able to do. We came back, we tweaked it a little bit more, and then finally we came up with set family division recommended time standards. In your table you have an AM. Now this isn't so recent, but I signed it on November 13th, 2024, and a special thank you to the chief. Nothing happens in the family division without first consultation and approval and support of the chief. And I mean, she was right there, absolutely, yes. And I'm pretty sure most of the other divisions have it. But family, I think, was really a pioneer because we really wanted to make sure that we have this as a tool. In your table, you have the AM. And there's a lot of language in the front, but if you go to the final page, really, that's what the information that you need to have. And really, the recommended time standards is envisioned is what you should expect to have a hearing, taking into consideration the availability of the other side. So if you're available, but the other side's not available, obviously, we have to take that into consideration, right? It's from the time that you contact the judicial assistant as well. But if you're asking for example, a 30-minute hearing, the expectation is that it should take no more than 30 business days for that matter. And it's 30 business days. And I have to stress, it's not just from what you're asking for. The judges and I think in every division, certainly in mine, if you email my division email, I get BCC. So I see every single email that gets sent. Which means if you're following the instructions and requesting a hearing, you may request 15 minutes for that motion for a psychological evaluation, but it may not be necessarily what you're going to get in terms of a 15-minute hearing, because realistically, we know in family, there are very few things that really can get accomplished in 15. So it's really the amount of time that the judicial officer determines is needed for this hearing. I know that the unsaid rumor out there is, oh, if I'll ask for 15 minutes or 30 minutes, then I'll get a quicker hearing. Not necessarily, because the judge is obviously going to look at to see what really is needed for that hearing. But if you're asking for 30 minute, if the hearing merits 30 minutes, then you should expect a date to be offered 30 business days. If it's a hearing that takes up to an hour, you should expect 45 business days. If it's a 3-hour hearing, it's 60 business days. And if it's up to 1 day, it's 120 business days. I have to stress it's business days, so mark the calendar accordingly. Why do I share this with, and I've been sharing this, this by the way is on my website, if you need it, if you need to attach it in your email when you're requesting a hearing from the JA, feel free, you can just find it on my website. And I've been stressing this AM to as many lawyers as possible because I know, life sometimes, gets in the way. The JAs have a lot to juggle, and sometimes the date that you get from the JA may not be consistent with that AM. Well, you have something in writing whereby you can request that hearing date. If the JA is offering you 2 or 3 dates, really at least one of those dates should be consistent with these recommended time standards. This is something that the entire division really embraced and voted on and agreed. And we did this, like I said, I signed this AM in November of 24, but this is really something that we embarked on about a year and a half before. So I think it is one of the key ways to be able to, again, I circle back, treat families in the same way that I would want my sister, if she was going through a divorce, to be treated. Please feel free to use this AM. Tell your assistants to feel free to use them. Not all the dates that the JA that offers may be consistent with this AM, but at least one of them really should be. So what else is an updates in the family division? We talked about recommended time standards for scheduling hearings. And then we have Supreme Court time standards for concluding cases. Many of you may have heard already some of the judges, some of the general magistrates addressing the Supreme Court last year reiterated the time standards that really the majority of family cases should take, contested cases should take in order to conclude. This is nothing new. This has been in the rules from before, but I like to say that the recent rules, the Supreme Court kind of said, we really mean it. Time standards to conclude. The majority of the cases should conclude, again, contested cases, within 180 days. That's quick. There's no, I mean, it's quick. And I see a very well-respected lawyer who's saying that's impossible. And it's being recorded, so I'll simply say that's quick. And the rule does not say 180 days from service, even though there's another rule that says you have 120 days to effectuate the service. So, what does that mean? What it means is that the judges and the general magistrates, because we have to follow the Florida Supreme Court, and they've made it very clear. In fact, now there are quarterly reporting requirements for every division, including family, of the cases that have not met the 180 days. Now, I like to say remember, if you look at the rule, it says the majority of cases. It doesn't say there's an exception. The word exception's not there. However, the rule specifically says that there are some cases, due to their complexity, that's the word that the rule uses, may not conclude within the 180 days. Which means, if you have that case that cannot conclude in 180 days, well, and that CMC maybe ask the judge for that finding of complexity, because it's clear that the rule does anticipate not all cases are going to conclude within the 180 days, although the rule says the majority of cases shall conclude within 180 days. It just has that complexity carved out. But why do I bring this up? Because as a consequence of the rule, as a consequence of the reminder from the Supreme Court, you'll have noticed undoubtedly the judges are moving the cases along. And how do judges move the cases along? Well, through orders. I'm a true believer in case management conference. I believe it all goes back to case management in every division, but especially in the family division. Again, the parties want to be in front of the judge, and case management is a wonderful opportunity to be in front of the judge. It's no longer just that the lawyer's telling the clients, yes, you have to turn over that discovery. It's the judge saying, there are deadlines, you have to meet it, and if you don't meet those orders, there's going to be consequences. Case management, I think, is a wonderful tool for the judge really to assist the families and to move the case along. Remember, case management is not an evidentiary hearing. I like to start off all of my CMCs explaining to the parties, it's not an evidentiary hearing, it's not a final hearing. The main purpose is to move the case along, to see what the court can do in order to assist the parties to come to a conclusion. But you're going to see, as a consequence of the Supreme Court's time standards, that there are going to be numerous orders that are entered in cases. The days of when a case, you file a motion, and undoubtedly, I know lawyers in this room wouldn't do it, but that you file a motion and then you don't notice it, those are gone. Why? Because you file a motion, you're going to get an order, undoubtedly. And if you didn't notice it, it may not be with the time amount that you requested, right? So if you file a motion for extension of time, if you file any motion, notice it. The easiest way to be in front of the judge is on the motion calendar. Now, obviously, not every motion can be on the motion calendar. My personal motion calendar is twice a week, Wednesdays and Fridays at 8:45. I do it intentionally early so it doesn't interfere with lawyers' depots and trials schedule. But that's the quickest way to be in front of me. Any type of motion that is for discovery purposes. If you can't come to an agreement with the other side, just notice it. on the motion calendar. For my motion calendar, all you need is 7 working days and an attempt to meet and confer. So be absolutely aware of the orders that were entered on the case. There are many judges that if they enter that order, I urge the judges to please be mindful of, if the order said to do something within 7 days, to just perhaps enter a second order to attend mediation, to effectuate service. Remember, every judge is an independent judicial officer, and some judges may move their cases along quicker than others. So please be mindful of the orders that are on the cases. Those are the tools that the judges are using in order to move the cases along. Case management conferences and orders. Please be very much deadline aware of those deadlines. The third thing I wanted to talk very quickly is, I'm a firm believer to use your motion calendar in the best way possible and the most fruitful way possible. Obviously, you have to know your audience. So if you have a particular judge that doesn't appreciate so many motions on the motion calendar, maybe think twice. However, I encourage the attorneys and I encourage all of the judges and the general magistrates to allow the lawyers to use that motion calendar in the best way. And what do I mean by that? You have that hearing, you have that motion that you filed, that's an evidentiary hearing, and you email the other side and crickets. You all know, right? And you send that second email and crickets. And you're caught up because you look at the website of the judge and it says you have to meet and confer, you have to see the other lawyer's availability. At the same time, your client is saying, why haven't you done anything? Why aren't you scheduling this motion? In my division, and I encourage the judges, all of the judges and the general magistrates to do it in the same way. There are other judges, if you go on the website, they have the same language. If you go on my website, you will see this is only for motion calendar. If you have to attempt to meet and confer. And if you are unable, after you attempt to meet and confer, you can unilaterally set the matter within 7 working days. Now, what does that mean? If it's an evidentiary matter, I'm not going to be able to hear the evidentiary matter on the motion calendar, right? But I'm going to give you a hearing right there and then. And I'll give you the perfect example. I ruled on the matter, so I can share it with you. I had a motion for a minor child to attend a graduation field trip that was scheduled for 3 a.m. today. The attorney had been trying to meet and confer. There were different issues with the clients. The attorney contacted my judicial assistant. My judicial assistant said, look at the website, notice it on the motion calendar. And it was on yesterday, 8:45. I couldn't hear it on my motion calendar. I scheduled it for 4:30 yesterday, and that family got a ruling. So I believe that the motion calendar, and again, I'm not suggesting that you expect that evidentiary hearings are going to be heard on the motion calendar. What I'm suggesting is you use the motion calendar to at the maximum capability. I like to say that no one has the right to hijack the calendar, and so if you need that hearing and you're not getting any feedback or any returns on the emails, then perhaps that's the best way to go. And then finally, I'd like to end this with saying, so training is something that is very, very close to my heart in the family division. You heard many years ago in the 90s, I was a prosecutor in the state attorney's office. I love being a trial, I love trying cases. But I also was the training director, and I wanted to bring some of that to the family division because I believe it is crucial. And I'm not just talking about for the lawyers, I'm talking about for the judges, for the general magistrates, for the case managers, for everybody. We have, what I will not so humbly call as the best training program, I believe, in the entire United States, certainly in the state of Florida. in terms of training. We have a boot camp training program in the family division that all incoming family judges have to go through before you start in the division, and it's pretty immersive. The boot camp training program is comprised of, I sit with them first for about 3 hours where we go through all procedure. We do 5 hours where several judges and general magistrates all take part in explaining all of the different elements of the different petitions that you see in the division. I sit with every judge that starts in the division their first week, so that you have someone right there sitting next to you. I give them training materials, including a flash drive with sample orders. It's pretty immersive. We also have ongoing training and 2 different types of trainings. The first one is the in-house training, where it's just for the judges and the general magistrates. It's really, I like to call it's cozy training. It's training really conducive where the judges will feel comfortable, everyone will feel comfortable to be able to ask questions. So we don't invite any attorneys or anybody from the outside, since realistically, the judges are not going to ask questions if it's in a room filled with lawyers. And we do that every month. And it's on a continued basis. Different topics that come up. We also have what we call the Lunch and Learns. If you haven't, if you're not a part of the mailing list, the invite list, just see me after, just shoot me an email after. Our Lunch and Learns are fabulous. They are monthly trainings that we have. We have, I think, up to 120, 130 lawyers at RSVP. A minimum of like 80 or 90 lawyers attend every single month. It's free CLE credits, so it's like a win-win. We apply for CLE, CJE credits, and it's on continued ed. They are fabulous. They are not only, I like to say they are beefy, they're not only on services that are authored through the division, and obviously services are very important, but also I call it the lit skills section. So we, next month we're doing part 2 of introducing bank records. Judge Diaz and I are doing it. We've had different trainings on objections, on hearsay. They're substantial. They are, I think, a wonderful part, and I think one of the reasons why it works is when you all, I get phone calls every day. I have really a true open door policy. Anybody that calls me and says, I really, wish this, maybe we're discussing an area of the law, and maybe there was some disagreement with the area of the law, you better believe that the training in that area is probably going to show up either for in-house or for the lunch and learn. If the judges talk all the time, right? If the judges are saying, I wish maybe there was a little bit more robust knowledge on motions for contempt. You better believe we're going to have a motion for contempt. So please, if you are not on the list, reach out to me. Thank you so much for being here. A very big shout out again to Karen, Dade Legal Aid, and thank you so much for being here.
Shout out to Esther too for helping us with everything. Thank you. It's been terrific today.
Thank you, Your Honor. Thank you for having us here. Oh, I've been told I don't need a mic, but anyway, thank you to the courts. Thank you to everyone for being here, and thanks to our incredible team at Dade Legal Aid. Let's give it up for the legal aid people. And our amazing moderators and the incredible sponsors and all the voluntary bar sponsors and the court team. And of course our pro bono lawyers and the honorees we're going to mention later in the program. There's one very significant person who isn't here today, Maurice J. Kuttner, who was really the heart and soul and helped this program get to 33 years. And it's ironic because, I don't know, 20, 30 years ago, I was talking to Jackie Valdespino, and she said, why don't I have Maurice J. Kuttner come speak at one of the seminars? He's incredible. I just heard him speaking. He'll really do wonders for you all. So I called him up, asked him to speak. He said, how long? An hour, a day, a week. He offered, and he also, as those of you who knew him, he walked up and down the aisles to make sure you were paying attention, and he came to get to know you, and he was a very special person, like Jackie Valdespino. Jackie's won the Tobias Simon Pro Bono Award. She's done endless work. She has really followed in his footsteps. And today's seminar is in his honor and in his memory, and we wish that Maury Kuttner could still be here with us. But fortunately, we have great memories and have learned so much about how to be a better lawyer, how to be a better person. And this year, for the first year, we're giving the, come on up, stand for you too. We're gonna give the first annual Maury J. Kuttner Excellence in Family Law Award to Jackie Valdespino for all of the years of her dedicated service. Very special, and we're so appreciative of everything you've done for legal aid and pro bono clients, and taking especially guardian ad litem cases. And I know you prepared something because we couldn't surprise you. We had to, we want to surprise you, but also the judge would like to make a few remarks as well.
So I want to congratulate Jackie, her husband, and her son who are in the back. Please wave. Her dear best friend, Marsha. This award, I had the honor of presiding over cases that Mr. Kuttner was handling, and also the Jackie. And I cannot think of anyone that deserves this award more than Jackie. I've had Jackie in cases where she was the guardian. I've had Jackie where she was counsel. I had a case, an amazing case that Jackie and Marsha represented a client. For those of you that knew Maurice, he was, very special, so professional. No matter how heated it got in the courtroom, he was like this, unflappable. Was the epitome of professionalism. Really believed in mentorship. And to have Jackie, for those of you that have not seen her, have not had her on the other side, you'll see when you do. So tenacious, doesn't stop, is such a hard working ethic. Amazing, because does not stop working, but always so professional, so prepared. It's really the type of lawyer that a judge wants to have, the kind of lawyer that a judge smiles when they take the bench and see. So, Jackie, congratulations, so well deserved. Really, congratulations on this, and a big congratulations to the family.
Before she makes her remarks, I'm going to just mention that we are going to be on time. Don't worry. We have a change in our program, and our next speaker is going to be on time, and our break will be on time, and not to worry, and she has a few remarks.
Good morning, and may it please the members of the bench, the staff and attorneys of Put Something Back and Dade Legal Aid, esteemed members of the bar, my friends and family. I am both humbled and proud to receive this award. Thank you to Put Something Back and to Dade Legal Aid, and especially to Karen Lattis. You and your team work endlessly to assist us in fulfilling our pro bono and CLE hours. Thank you. Thank you also to our sponsors, because this event would not be possible without you, and I truly appreciate it. I also want to thank my husband, Aldo Risco, and my son, Luca, because those endless hours serving or preparing would not be possible without the support I receive from them. I'm not sure that I am entirely deserving of walking in his path, but I assure you that I will endeavor until the last day of my practicing hour to continue the legacy of Maurice J. Kudner. Known affectionately to friends and family simply as Kudner or Cut. He was a beloved husband, a dedicated father, an esteemed attorney, a leader, a loyal friend, a gracious mentor, a master of his craft, a passionate advocate for his community, an expert seaman, a muscle car enthusiast, a motorcycle rider, and a competitor on the tennis court. Kudner was both a master of his craft and a passionate advocate for justice. Those of us who counted him as a friend, colleague, or mentor are richer because of the life he shared with us. Kudner believed deeply in giving back to the community. His public service began with his first legal job. After earning his law degree, he joined the JAG Corps, marrying his strong sense of patriotism with his passion for the law. I would have loved to have witnessed Kudner at one of his JAG Corps trials. Actually, often when I watch A Few Good Men, and I watch it a lot, I imagine Kudner in his uniform, advocating for the Corps as he strolled throughout the courtroom, educating everyone. Despite not needing to serve in order to establish his reputation, Kudner demonstrated his innate generosity as an active volunteer with Put Something Back and Dade Legal Aid. He never said no to speaking at Nuts and Bolts seminar. And for those of us that had the honor of hearing him speak at these seminars, also remember that it was rare to find other lawyers with his credentials giving of their time. He always shared his forms, and he always credited his beloved Marisol for maintaining the quality of forms and the procedures at his firm. My, as I am sure many of your, intake sheets, retainer agreements, and other office forms were born from a Kudner form. I remember once randomly at the supermarket running into a former client of Kudner's who explained that he took on her child-centered case even though she could not afford to pay him after her initial attorney withdrew. She appreciatively explained that Kudner represented her, protecting her children through the process until the case was successfully completed. He never touted these acts of service. Rather, he served silently, knowing that his reward was not the praise or the recognition, but rather the act of giving without expectation. His ongoing commitment to supporting those in need became an integral part of his legacy, serving as a shining example for all of us who knew him. Never one to take himself too seriously, Kudner charmed everyone around him with his easygoing manner and endless stories that ended in laughter. I was extremely fortunate in 1999 at my first ABA Family Law Section meeting in San Diego, California, that Burton Young and Maurice Kudner approached me, took me aside, spoke to me at length about the importance of raising the level of the bar and the bench and of service to others. Both these men were pillars of the community and exemplary lawyers, exemplary family lawyers. Kudner explained to me that the privilege to practice law was accompanied by the responsibility to serve professional associations and those less fortunate. I did not realize it at that moment, but Cudner and Burton guiding me was one of the most important paths that have led me here today. I remember the first case I had with Cudner. The marital estate was $1 million, a whopping $1 million at that time. I remember taking Cudner's first call. I was stunned and scared to hear his bellowing confidence at the other end of the line. He opened with, "Valdespino, I don't take these cases, but I took it because you were on the other side. You need to promise me that you will work with me and not against me. We together are going to do what's right. I want you to come to my office tomorrow. You can choose the time. And we're going to negotiate a number of preliminary orders. And then we're gonna present them to Judge Bailey. We're gonna go before her in person to take her the orders so that she knows that we're doing the right thing for this family. Do you understand me?" Then he hung up without waiting for an answer. We negotiated the orders, we got them entered, and eventually the case settled at mediation. I remember another case I had with him. That was a litigated case. I was extremely honored that he asked me to come on as co-counsel and handle the children's issues while he handled the financial issues. In the middle of trial, just before cross-examining their expert, he whispered in my ear, "Valdespino, watch this." He gets up to cross-examine the witness. He pulls counsel's chair to the middle of the courtroom. He turns to the judge and says, "Your Honor, with the court's permission, I want to sit here rather than stand behind the podium because I want to be at eye level with this witness. May I, Judge? Thank you." Again, he didn't wait for an answer. The tone of his voice, his position sitting there on equal par with the witness, his matter-of-fact candor, all were the physical manifestation of his friendliness as he devoured the direct examination on cross. But the most impactful gesture, other than being my mentor, that Cudner had with me was when he called me one day after I had sent him a proposed marital settlement agreement on a case we were litigating against each other. Again, "Valdespino, I'm sitting here with my associate, Tony, and he just presented to me a new case that I want you to read. I'll fax it over right now." Click. He hung up without allowing me to say a word. The case was at least 3 years old. I instantly knew it wasn't a new one. The case was about capital gains. I had neglected, in my proposed marital settlement agreement, to account for the capital gains on the property. He gently, without shaming me, alerted me to a case that I had failed to account for, and my omission would have resulted in an injustice to my client, not to mention malpractice. He lived his truth. I lay witness to his unwavering passion for the gracious practice of law in a transparent manner. Cudner was my mentor. I was very lucky that he stepped into that role for me. He was known for being approachable, funny, sincere, passionate, and deeply devoted to the people and the things he loved. His innovative approach to the law influenced many, yet he made it a point to never take himself too seriously, often lightening legal discussions with his characteristic wit. Cudner's everyday was granted in his heartfelt devotion to the practice of law in a manner that resulted in professionalism and unfelt results. Thank you again for this recognition. I urge each and every young lawyer, or even a more experienced lawyer, to cultivate a mentorship relationship and work to serve and raise the level of the bar and bench, as Cudner did until his final breath. I also remind you of the importance of serving those less fortunate. And I thank those of you here today that have agreed to take a case. The halls of justice are often dark and uncharted for those that are less fortunate and unknowledgeable. You have the opportunity, each time you accept a pro bono case, to be the shining light, to share the light, to guide in the light. Embrace these books. Sign up for a case. Thank you again.
Thank you, Jackie Valdez-Pino. I like to think of you as my older sister. I'm Valdez Alba, but you're Valdez-Pino, so we're the same family. Somewhere in that DNA, I'm sure, ancestors got together. You know, some people say that, I read somewhere that being an attorney is easy. It's like riding a bike. It's as easy as riding a bike, except the bike's on fire, you're on fire, and everything is on fire. And it feels like that sometimes. Not all the time. This next speaker, oh, and I want to talk to you guys. This next speaker is going to have some slides. There's going to be several speakers that have slides. Unfortunately, the speaker that was going to talk to us about child support enforcement wasn't able to make it today, but we're going to give you their slides as well. You know, I went to a continued education recently, and I asked for the slides, and they said, we don't give slides. But we're going to give you guys all of the slides. So you're going to have all this information. This next speaker is a experienced litigator. You could say he's a frequent lecturer, I would say. He's a Supreme Court certified, family Supreme Court certified mediator. He was recognized as one of the best lawyers in the Ones to Watch for America in 2023. And he is the current president of the Inns of Court, which is a very great sponsor of this event. And he's also runs several of the family law section committees. I know because I actually ran one with him for a while. So he's going to be a fantastic speaker today. And our next speaker is Mark Joseph.
Sir, it's always a pleasure to get a chance to speak here. And as everybody's going to probably mention, obviously, please take a case, whether it be as a guardian or mainly as a guardian. A lot of these cases need them. I mean, even if it's just on limited issues, just get the clarification. A lot of these families need that, and would benefit from your experience, from your involvement in those cases. So please take a case, be involved, and help us help these families. So what I'm going to talk about is equitable distribution. If I could just put, somebody can get it into full slide. Is it right here? All right, so today I'm going to talk to you guys about equitable distribution. This is an important area that I feel like, you know, especially if you have paternity cases, you don't get them. Honestly, I'm not going to say it's boring, but it's very number heavy, which us as lawyers tend to not do so well in. But it's so important that you guys get to know this. And the biggest reason why this PowerPoint doesn't have a bunch of case law, but I will tell you much of the case law. Aside from doing the case law every once in a while, I'll know the attorneys that are on the other side. And I speak to them about what happened. And a lot of the reversal that occur is because the courts are not getting the proper facts or evidence to make their decisions. So understand that a lot of these times when we get these cases kicked back for equitable distribution, it's because us as attorneys, we're not giving the court what it needs to make these decisions. So this is going to be one of those times where I say, help the courts, help us. So what I'm going to try to do is give you a breakdown here. If you have any questions, especially when it comes into the evidentiary part of this, I try my best to, I mentioned little points of it, but if you have a specific question on it, please ask us. We have a little bit more time than we plan to have, so I'm going to try to get you guys here so you guys get to your break properly. But if you do have those questions, please share. And I've sprinkled a few quotes that I like to do to summarize some of these points. This is a quick table of contents what we're going to discuss today, but we can just get right in it. Marriage is grand, divorce is 20 grand, and half of your stuff. And here's another quote for you. Dividing marital property is like cutting a cake with your ex. Everyone wants the bigger slice, and nobody trusts the other with the knife. I have a few of these. Let me know if they hit or miss. You know. But one of my mentors, Ron, he'll give you actual pictures and stuff. I like the quotes. So. All right. So the purpose of equitable distribution. It exists mainly for fairness. And in the back of all this equitable distribution, there is a theory of equity. Granted, the numbers tend to be where the courts start. However, if there's some equitable portion that needs to be looked at, that's something that does need to be brought up and presented, and make sure you have a solid argument for it. I'd like to always say the equity aspect is technically the exception, not the rule. Usually, a lot of the marital estate is put into numbers and divided accordingly. Generally speaking, I would say this is a lot of the point that you like to explain to clients, is that it's to reflect the partnership nature of the marriage. It's not always just a number. Sometimes it's some of the things that are put in, not just the actual efforts in the marriage financially, but the active appreciation of certain aspects of certain assets and whatnot, which we will discuss a little bit as well, and to disentangle financial relationships. That's also important when you think about it, because some couples have businesses together, and at some point this business needs to be dealt with as much as their marital relationship, and the court does have the authority to start dividing those things. So these are things you want to kind of take in mind when you think about equitable distribution. And to consider the spouse's future needs. That's one of the factors that is considered. One thing, generally speaking, for those who don't know, equitable distribution, when you look at, or when the courts look at the breakdown of everything on a case, obviously parenting issues and the children are paramount. However, when we get to the more financial aspects, equitable distribution gets dealt with before alimony, and especially before child support. Because what happens in equitable distribution can determine what will happen in alimony, and what happens in those two things can determine what will happen in child support. So when you do have these cases, there are things you want to keep in mind. The guiding principles that at least I believe, is it's equity over equality. It should be just, not necessarily 50%. And there is a portion of the equitable distribution statute that does talk about unequal equitable distribution, and again, as I mentioned before, the equity between parties. There is that presumption of equal split, but again, there is the exceptions that exist, and if you do feel like your case qualifies for that, or your client has that, you definitely want to present it and understand how to. And then it also encourages resolution. I mean, generally speaking, the numbers are the numbers, and we'll talk about it. However, what you value the numbers at, when you value the numbers, can become point of question. Who keeps what, how it's kept, all these things can become conversations that, in hopes you can settle in mediation, but you definitely want to understand it, so you can also be creative when it comes in mediation. A lot of equitable distribution cases, I feel, can be dealt with so much more creativity at the mediation table versus in front of the courtroom. And so that's something you definitely want to understand and keep in mind. Jackie just gave a perfect example. Things like capital gains actually matters. Just another simple example bouncing off that. Sometimes losses in tax returns can be a huge, even though it's technically, losses over future years. These are things people value depending on what their financial situation is. So there's a lot of ways that you can be creative in handling these cases that the court may or may not be able to do. And if the court can do it, you got to bring in experts. So it becomes more costly to try to make those points. But this is why I think understanding equitable distribution is so important. And just practically, you don't want to leave one party financially, more difficult than the other person. The theory of equitable distribution. You don't want any unjust enrichment if there shouldn't be. Usually you get that with non-marital versus marital properties, and sometimes you have commingling or active efforts to appreciate them. And to provide some finality and clarity to their financial relationships. Again, businesses, joint assets need to be divided and figured out. This is the more statutory framework. This is where we always start when we deal with these cases. This is where the courts are going to start. However, obviously, when you're mediating and trying to figure out the case, you can be a little bit more creative with it. The Florida Statute 61.075 does give Florida courts the power to determine equitable distribution of marital assets and liabilities. It applies to both real and personal property, tangible and intangible. So People who have book deals, music deals, royalties, etc. These things can also matter too, and these are also things that could be subject to equitable distribution in the case. So again, keep those things in mind. The key steps, this is going to be super important. This is just a line-by-line item, and what I normally suggest is this is how you want to present any sort of conversation about equitable distribution, either as a whole or a specific asset. It needs to be identified that if it's going to be marital or non-marital, keep in mind the courts do have to identify both the marital and non-marital assets that's presented to them. You have to you identify the asset and you classify it. It has to be classified as marital and non-marital. Then it has to be valued, and then it has to be distributed. We're going to talk about this in much more detail. Again, if you have any questions of any examples, we have some time, and I'd love to help you guys hamper to it. The people who may say that I'm wrong or have another strategy, I present that as well. I like to have many of these, the time that I do the nuts and bolts, be as collaborative as possible, because as professionals, we definitely learn from each other. So, the court must consider when deciding unequal equitable distribution. This is the exception, not the rule I'm talking about. These are the factors here. I'm just going to go through them really quickly. The contributions to the marriage, the economic circumstances, the duration of the marriage, the interruption of personal careers, educational opportunities, contributions to career or education of the other spouse, desire to retain a specific asset, contributions to the acquisition of any specific assets or debts, and intentional waste, dissipation, or destruction of assets. So focusing on the classification timing is what's important to note, that it's the marital and non-marital has a default cutoff date. If it's before the marriage, it's presumed marital. If it's during the marriage, it's presumed marital. And if it's after the filing, it's presumed non-marital again. The court can use a different date that they feel is more equitable to determine these things. And just to understand where classification is important, it also talks about the presumptions. So if it's an asset that's accumulated during the marriage, you presume it's marital. If the person who wants to declare non-marital would have the burden to prove to the court that it shouldn't be declared non-marital. If it's something before the marriage, but should be considered marital, or a party wants to consider marital, that person who wants to have it declared marital has the burden of trying to prove to the court that it should be non-marital. So classification is important to understand where the asset being marital or non-marital starts, and then it lets you know that if you want something different, that you have that burden. The timing also, generally speaking, it could be the trial date, it could be the filing date, it could be, there's multiple times that the court can use. And this is usually where, when you get into equitable distribution, especially in trial, you end up in some sort of battles with court. Because you have a situation, just for example's sake, if someone, at the time the divorce was filed, the person left the home. But the divorce doesn't happen, of course we're strict on guidelines now, within the 6 months that we're required to maintain our cases. And so there's been a 6-month gap between when the case starts and when the home may be valued or may be considered. Which one is equitable? Which one is right? That's up to you guys, if you can't figure it out in mediation, to bring to the court's attention into why you think that's the case. And this is what I mean by, if you want the courts to consider something, you have to present the evidence as to why. You gotta be solid. Did the person who left the home, did they still contribute to the home? Did they still pay mortgages or help with the mortgage or help with those expenses even though we're living there? Did they completely just cut themselves off to it? Was there a significant amount of the principal paid during that period? These are all conversations, and these are all things that you want to bring to the court's attention when you're discussing it. And again, a lot of the case law we see is when certain findings are made is because of the lack of evidence that the court's presented with to even make these decisions. The courts can differentiate from the different points of assets. I talked about homes, but there's things like stocks and things such as the like. Volatility and fluctuation are some of the things you want to think about. Changes in control or possession of the property, or delays or dissipation by a party to that property. These are all things you want to kind of think about in your mind when you're putting this case together, whether it be for mediation or trial. In terms of order of adjudication, the equitable distribution, as I mentioned before, is addressed typically before alimony and child support. And as I mentioned before, because what happens in that, well, one is statutory, and two, what happens in equitable distribution can determine what we're going to do with alimony and child support. Procedural requirements as it relates to equitable distribution. As soon as equitable distribution is pled, 12.285 does kick into effect. There are exceptions where you don't have to comply with 12.285. Usually it's when there's no financial matters and there's no minor children, which would activate child support. But once there's, I mean, obviously those things can also activate it, but once you get equitable distribution, those things need to be considered. What I try to stress people is that when you're doing your financial disclosure, it's important when you're, especially if you're even going into a mediation, make sure you do your due diligence when it comes to financial disclosure. Because yes, there are some procedures in which if someone doesn't disclose an asset or an asset isn't considered, you can come back to court. You don't want those problems. So definitely, although 12.285 gives a decent amount of things that you can ask for, definitely speak to the client. Find out there's certain things that they may be, that they're curious about or that may exist or may not. Subsequent requests for production may also be important. I'm not a fan of just asking for things just to ask for them, but this is why you want to kind of double check with your client if certain things don't exist. I mean, I'm sure you guys deal with it day in and day out. At this point of divorce, no one trusts the other person, so everybody thinks someone's hiding something. There's money different places. We're in Miami, money's in different countries under other people's names. Mandatory disclosure may not consider that. And, especially when it comes up, I mean, obviously sometimes clients may be a little bit more paranoid, but you do need to dig into that, and you want to know the multiple vehicles you can use to dig into that. But the start point is usually 12.285. Temporary relief. Equitable distribution is a funny animal in that sense that there is some temporary relief that can be done, but it's not as absolute. You can ask for temporary use of a property or possession, equitable occupancy, and payment of joint liabilities. We do have a status quo order that does handle a lot of that, but sometimes that's not enough. Sometimes you have to file a motion and get them in there for that. And sometimes, and the statute, the changes to 61.075 has kind of went a little further and allow for partial equitable distribution, but you have to have those findings and you have to make sure you present the court with whatever it needs to consider to seriously, to get that relief. Although it can kind of be, I don't say fixed up, but although these things can be considered at the final distribution of the party, so just consider overall in your case what you need to get done. And what I tend to say is don't try to touch too much unless you really, really have to. If you need someone to make sure they're maintaining insurance benefits for children, well, the assets not for children, their schooling, but anything that you need to be maintained during dependency of the dissolution, make sure you request it from the court and make sure you're ready to present the evidence that you need to have the court make the ruling that you think is fair for this family. Experts help for a lot of these things. Equitable distribution, you can have experts for a lot of different things. Equitable distribution, I find, is when experts become most important because aside from determining, people can, obviously there's values to houses, you do your appraisal or whatnot, but there's more complicated matters. Sometimes people have jewelry, people have paintings and things such as that needs to be analyzed and appraised. Also, when you're looking for assets that may be hidden, forensic accountants are people who we can possibly use. Obviously, it's not absolute. I mean, the perfect example I use is if you have someone who makes a lot of their money cash and they keep money in a shoebox somewhere, there's not much I can really do with that. And fun fact with that, look, just having a video of someone, of a party just showing the wad of cash is not enough to get a determination of that wad of cash. Guess what you have to do? You have to have video of them counting it. And you gotta somehow prove that that money still exists, and if it doesn't, if there's a potential dissipation. So that happens when we have a lot of clients who have those cash assets and things like that. And one thing that doesn't get used often, at least not in my practice, is request to access entry on pawn land. So it gets really complicated and you can get really creative. What I usually warn people is it can get really evasive too. So just be careful. Just because you have money in a wad of cash somewhere does not mean in theory someone can't get a court order to make sure that safe or wherever is not open until someone can review it and there is a full accounting of the money in there. So these are little things that you have to keep in mind that sometimes experts can't always help with, but things you want to look at when you deal with equitable distribution cases. The distribution process. Dividing assets in a divorce is a lot like a garage sale. One person's treasure is the other's. You can keep it. The identification of the assets and liabilities, as I mentioned, the court begins by identifying all the assets and liabilities owned by either spouse. And then it creates basically the inventory. As I mentioned, full financial disclosure you want to have. It may include real property, bank accounts, retirement accounts, businesses, personal property, credit card debt, and loans. And failure to disclose is grounds for sanctions and post-judgment relief. Just really quick, 12.540 is the rule that usually emphasizes. There's a specific catch-all that's very unique in family law, that a fraudulent financial affidavit has no time frame. You can, you find out, if your client finds out 5 years from now there was an account that existed that wasn't distributed, you can end up back in court 5 years from now saying, hey, you forgot to disclose this, or this wasn't divided. And again, fraudulent financial affidavit. I can go on and on and on the importance of making sure you have a solid, detailed financial affidavit. But that's a different presentation for a different day, but make sure, especially when you're doing equitable distribution, that part that talks about assets and liabilities, make sure it is as detailed as reasonably can be if you don't want to have to face one coming back to court unreasonably. The classifications, which is 61.056A, is presumed to include assets acquired by the spouse during the marriage, retirements and pensions, personal property held jointly, and appreciation of value of the non-marital assets due to marital efforts for use of marital funds. This gets really, really complicated. There was case law, copy that was now codified, and it's essentially a long mathematical equation. And if you're lucky, you do have a court that definitely understands that, as we do here in Miami-Dade County. However, you still need to present the evidence. The court can only go so far to kind of take that leap. You still need to give them those numbers and figures, especially when you're talking about active and passive appreciations. Those numbers can vary out. Yeah, okay, yeah, they spent $20,000 to get that roof. That's a little bit more detailed. However, is that the exact amount of money that the house appraisal changed because of the inclusion of the roof? Does it more? Was it less? Did you change the bathroom? Did you upgrade the kitchen? Does that upgrade to the kitchen? Was it something that generally increased the value, or just more about you enjoyed it so you made it your way? But will it sell differently? These are all questions that we can't answer as attorneys, because one, we don't testify, and unless you have a hobby in interior design or real estate, you may not know personally. And the courts cannot presume and infer. So these are things that I keep saying you need to bring in as evidence. And the experts who do this, I'll tell you right now, are not necessarily the cheapest. That being said, these are the things you want to think about when you bring it to the mediation table. Don't let it get the trial to figure this out, especially in, we have families who can easily afford this, and we have families who, between our fees and these expert fees, it becomes very, very costly. So you want to be very considerate of these things. The non-marital, it talks about here what it's presumed to include: the property acquired before the marriage, inheritance, gifts, assets excluded by valid written agreements, that includes a prenup, and income from non-marital assets unless commingled or used in marital funds. There's a nice fun list of case law that you look at when you go to non-marital and marital versus commingling versus not commingling, whether you can trace it back. It gets fun and complicated. Every asset is treated differently. All I can say is you just prepare your evidence for it. I won't go into it in detail unless someone has a specific question or example, but these are things you do want to consider as well. Common classification changes, again, the commingling. The simplest one I can tell you is if you have a non-marital account and you start moving and you have your money direct deposit into that non-marital account, and then you get married. Once that money keeps going in there, guess what? There's a theory that you commingled that property. These are things that people want to be mindful of, usually before marriage, but don't think about that, and this is where we end up in this situation. Transmutation of an asset, non-marital asset, treating a non-marital asset as marital. You have, when you transfer values of the home, these are things. Businesses, when you have a marital asset that you transfer into a non-marital business. You may not transmute, but depending on what the asset is and how important it is to the business, maybe it is. If it's a property management holding company, it had no properties in there, but you transfer marital property into it, what does it do to the business? I don't know, that's where you got to figure out. But these are things you want to keep in consideration. And then you talk about the active versus passive. Homes, again, are the typical version we use here. There is non-marital homes that that one party moves into. However, they may put money into rebuilding it. They may remodel it. They may do certain things to adjust the value of it, which is active. And then there's the passive growth of that property, whether it be just through the existence through general market forces or any actions that are taken by that person. There is some interesting line of case law that talks about this with stocks. Anybody who does dabble in stock trading, you can passively let your stocks grow, or you can be more active with the decisions to trade. There's a line of case law that talks about whether it should be considered active and passive. Case law aside, these are all arguments that become conversations to be had when you're at the mediation table and when you're in front of the judge in the courtroom, judge or magistrates in the courtroom. This is what I'll tell you about before, the burden of proof. We'll skip over that, but again, if you're trying to move away from the presumption that occurs, so again, marital is usually anything within the marriage, from the date of marriage to the filing, that's presumed marital. If you want something to consider not marital, it's your burden. If it's anything that's outside of that, so before the marriage or after the date of filing, that's considered non-marital. If you want that marital, it's your burden. You're the one who has to prove what you want to do, whether you want the court to consider otherwise. This also talks about that, the burden. Other burden shifting situations is joint titling, again, commingling accounts. I want to skip to the practice tip. Always advise clients to keep clear records and avoid joint titling or use of non-marital funds without written agreements if classification will matter. Basically, make sure you have to understand it. It's not as simple as saying, oh, is this bill being paid? You got to know how it's being paid, under what asset, what account. This kind of becomes a conversation, potential dissipation cases as well. And there's a line of case law that says this is considered dissipation, but then there's other line of case law that says, depending on what the circumstances is, it is dissipation. So you want to be very clear in understanding what is being paid and how it's being paid and from what accounts or from what source of income is being paid from. In divorce, everything has a value, except your dignity. That one's true. Dividing assets is easy until someone has to put a dollar value on the dog, the blender, and the wedding china they've never used. And you'd be shocked and, well, I'm pretty sure you guys have, at some way, shape, or form, had to argue about a dog. Blenders, ninja blenders are pretty, I don't know. I don't have one, but people put a premium on them. And the wedding china, at this point, I don't even know. Well, what happens is, one argument I had is a conversion. I'm Haitian, and I was representing a Haitian client. And it was some old school china and an old school, and I'm sure other cultures have it, just in this old thing that no one ever used, but it was apparently a gift, and it was a conversation, if it was a gift directly to them, or was it to them as a couple, or was it as an individual? And you end up in potential litigation on that because, again, you can't put a price on principle. That's the favorite phrase. My answer to that always is, yes, I can. It's my trial retainer. But that being said, these things are very important, and yes, you can settle them, but you can't split wedding china in half. You can't split china and that silverware in half. You can't split the old school tables that are like 30 years old that are full wood that you're not carrying out that house. You don't want to carry it out the house, but people will litigate tooth and nail for it. You never really know what you're worth until your spouse tries to value you in court. Truer words are never said. This is about valuation experts, because nothing says I love you like arguing over the depreciation schedule of a sectional sofa. Which, by the way, if you really have to do that in court, you have to determine its depreciated value, and there is a way to do that. I've learned, and it's not worth the money you spend to do it. I'll tell you that right now. But the valuation of assets and equitable distribution, the timing, there is no fixed rule. Court has discretion to select dates based on fairness. And understanding what I want to add to that is the three timing options: usually date of filing, date of separation, or date of trial. What's most important to note on this is the fact that it's not a once the court makes the decision, it's a decision for everything. The court can determine one account based on one of these terms, another account based on another term, one property based on one of these, another property based on them. So again, each individual item that's on that classification, that's on that chart, needs to be looked at from this lens. And it makes sense. I mean, to be quite honest with you, I mean, if it's the marital property that both parties stayed in during the entire marriage and even through the divorce proceeding, it may make sense to do it through trial because they've been living it. They're both living it. They're both contributing to it. But if you have a property that's a rental property and at some point one party just kind of stopped helping with it, another party didn't, and when they were asked to go help the tenant, they didn't want to help the tenant, but this one person was the one who totally handled it, it may be a different conversation of what date you want to use. And the same thing with accounts. One account may be used to be paid for the marital expenses, the other one just kind of helped. So those dates, those values, those items in terms of what date you use to value it, you definitely want to make sure you have that detail and ask, and I know it's a lot, but you have to ask the client about each one of those assets or each one of those debts for the court to properly consider it. The court can assign different, as I mentioned, the court can assign different valuation dates to different items. The methods of valuation also gets created. You have the real property, you have the license appraisal, which is what we normally use. Usually your mediation, someone ends up on Zillow or something like that. I'll tell you right now that usually tend not to be the most accurate. However, if you want to try to get a buffer to figure out where generally it'll fall, you can use that. However, you may want to get a license appraisal. Usually a joint appraiser usually helps if someone's trying to refinance about the other person. It doesn't matter what that appraiser says. It depends on what the bank says when it's time to refinance it. But these are things you want to be aware of. Bank statements, official statements tend to be the general way to look at it. Retirement and pension, usually we leave that to the quadro experts. We don't deal with that. That's a whole different ballgame. You can, but it's complicated. Businesses, you have expert valuations. There's very specific ways you can value a business. You can do it based on market, asset-based, personal property, or even fair market value. Those are three different concepts that get really advanced. However, your expert will explain it to you and you probably still won't understand it. But just understand, the value of a business just based on its assets and liabilities is not the same as if it has a book of business. It's also not the same on if you tried to sell the property. And these are all different things, and people start having different opinions on whether or not what value is based on what. You start talking about good enterprise versus personal goodwill. These are all things that make cases very complicated, and if you do not present the courts with the evidence, they're supposed to not consider it. And some of the case law says if they do consider it and they weren't supposed to, it's probably reversible. So understand and make sure your clients understand. Their cases can get really complicated and really expensive. And although we're here being nice and pro bono, not all of the accountants do that. They're like, look, you say that pro bono stuff for you. Some people do it low cost, but some of this stuff does require a lot of work and a lot of hours. And some of those costs you can't just do on a low cost. Some of them are just hard numbers that we got to figure out. So just make sure the clients understand that when they want to fight about everything. The liabilities are also something that usually gets ignored. Credit cards and loans, mortgages. Student loans is always an interesting one because people think like, you were in school during that marriage, that loan is also divisable. Now, whether it's fair to divise it, that's up to you, and whether or not you can figure it out in mediation and or trial. But if you're gonna take that position, make sure you give courts enough to make the decision you want them to make. Business debts is also an interesting one. What I've seen more and more, especially recently after COVID, is those SBA loans. Because those SBA loans are business, but they're also guaranteed by an individual. So those get really complicated, but these are things you have to think about when you're dividing someone's full marital estate. So even though it's a business debt or maybe a business debt, someone's personally guaranteed on that. We gotta figure that out too. And if you can't figure it out in mediation, you gotta give the courts the information to properly make that decision. The common disputes, again, competing expert. Usually, if one person has an expert, the other person should have an expert unless they can agree and stipulate. The good news is, in my experience, a lot of experts like to work with each other and try to get these numbers figured out. So hopefully if you get a situation like this, they can figure it out and start agreeing to some things. Asset appreciation and depreciation during litigation, that happens obviously. That makes it more complicated. The value of the house, the date of the filing may not be the same as the date of you're in mediation or a trial. You want to make sure you understand those things and figure out which one's more advantageous to your case. Hidden or unreported assets, we talked about that a little bit. The one that's paying down debts, again, we talked about that a little bit in terms of determination, the date that you want to use. And arguments over purposes of liabilities. Was a credit card used for family or personal expenses? These are all things you want to think about. Nothing says I loved you once like a spreadsheet and a forensic account. And when I tell you, to be completely frank with you, when you get into equitable distribution, if it's a simple estate and you can get some agreements, yes, you can probably do it amongst yourselves as attorneys, between attorneys at mediation, maybe even in trial. But a lot of these cases, people's assets are complicated. And it doesn't, you don't need to make a lot of money to have complicated equitable distribution. If someone's a self-employed person and they own a landscaping company, guess what? That landscaping company probably has a book of business. You may not know it, but the stuff they use can be expensive, and there's depreciation for that too. And in theory, landscaping companies can be sold, and so these are all things that become complicated. People have businesses, and unfortunately, you know, when people can't figure it out on their own, the court has to decide it. The court has to decide. We got to make it available to them. But sometimes it's not even worth it. Sometimes I'm at a mediation table. If the argument's about between $10,000 to $15,000 that we're fighting over, I'm like, look, you'll spend a lot more in trial and expert fees. Why are we doing this? And that difference, and that's to have a chance to get what you want. You may not get what you want. So, you know, a lot of times I say pointing that out to the clients is important. One party may receive more assets, but also receive more debts. That also starts into being creative. When if one person earns more, maybe they get more of the debts, but they're gonna get more of the assets. And sometimes people like to ignore that when you do a case, because they feel like, well, it's not fair because the numbers say they get this much. People tend to ignore debts. So make sure that's clear and understood when you're speaking to your clients. And then the courts can use offsets, credits, and unequal equitable distributions to balance certain outcomes. But again, if you don't give them the evidence, they're not supposed to do it. So again, make sure you're preparing your cases the way you need to make sure if there's certain results that you want to get, that you're preparing the courts to make that decision or can consider your position in terms of that position. In the end, no one really wants a dining room table, they just don't want the other person to have it. I actually disagree with this one. Again, I want you to try to find a durable dining room table nowadays that's being made nowadays. The ones from 20, 30 years ago are still kicking and solid. Granted, hard to move. I've had to move a expensive dining room table and a pool table. Those are the two most expensive things to move and get disassembled, reassembled properly. That being said, I like a solid dining room table. Overview of what happens after we start dividing things. Once the assets are divided and classified, the court must determine how to divide them equitably. Understand that's not always value. A lot of times I see this with cars. Sometimes cars are just cars. You might have the newer car that's financed versus the older car that's paid off. I mean, can you put a value over a car that has just all asset value versus one that's being financed? I say don't let the courts do that. If you can't figure out cars, I mean, we have a much more difficult issue. But usually we try to avoid that because those things come up. Equitable doesn't necessarily just mean value. Court is guided by the presumption of equal distribution unless evidence justifies otherwise. Starting point is always the statute. Equal means fair, not always identical, and the court may deviate from equitable distribution based on statutory factors already covered. That being said, make sure you guys present the courts with the evidence. In-kind distribution, sometimes it's not necessarily the value, it's just a specific asset. Makes it sometimes straightforward. Again, the car is a good example. The credits and set-offs you usually get when people are paying certain debts such as home mortgages, etc. Again, these are all things you want to present as evidence to the court if you want the court to consider things like credits and set-offs. And deferred sale or structured distribution is also important. One of the things that you can do in a divorce specifically is you can defer the sale of the home. And usually that tends to happen or is considered statutorily if someone's keeping the home until the children become 18. We're not selling the home today. We're selling the home once the youngest child turns 18. You want to look at that and make that consideration. And one other important point I want to make about sales of homes. Typically, if you settle the case, you're supposed to, people agree on a real estate agent and the home gets sold that way. Does anybody know how homes are supposed to be sold by the court? The courthouse steps, just like a regular foreclosure. A lot of people don't know this, and there's case law that will appeal a kickback. Courts tend to be generous in this situation. People don't appeal it. But just to be clear, the way the statute writes it, it's supposed to be sold at the courthouse steps. So just like how you would do anybody who's ever done a foreclosure, just like there's a listing done, it's done via there. It gets basically done just like civil court, and any sort of person who's looking for a good deal on a house can get it from there. Please keep that in mind when you're arguing over sales of homes, and that is statutory. And again, if someone challenges it in an appeal, I understand what we typically do in courts. Courts tend to try to be fair. People tend not to try to fight it. But if it is fought, understand the default, the way it's supposed to be done is it's courthouse steps. So if people worried about the value of the home because of the color of a bathroom or a kitchen, imagine when someone in the foreclosure similar sale buys it. The distribution of the asset, this is just basically the unequal equitable distribution again. These are things you consider for unequal, but also keep this in mind when you're arguing a position as it relates to how you want an asset to be divided, you want to consider these factors as well. These factors kind of operate for that as well. So, and the ability to maintain it. There's no point in giving someone a whole house if they can't afford the mortgage, or if it's going to have someone else's name on it. Can they refinance it? Can they assume the mortgage? These are all things you want to keep in mind when you're trying to even argue the position of how the property itself is divided and who gets what. This talks about unequal equitable distribution in a little bit more detail. Usually, commonly, it's one party dissipates an asset, or the court, and be specific, the court finds that there's a dissipation of the asset. Significant imbalance in economic prospects, or one party contributed significantly to a value of a retained asset. These are all things typically the courts take in mind, but again, this is not a finite list. If you have a case that you think the court should consider it, please put it to the court's attention and make sure you have the evidence, and then leave it in the court's hands if you can't settle it. Asset-specific considerations, the retirement accounts, usually we divide those via quadro. This is something that's very important. I have cases where people still don't understand this. IRAs typically are not divided via quadro, especially Roth IRAs. That's a basic transfer. Please don't stress your quadro expert by telling them when they're going to divide that Roth IRA. That's a simple direct transfer that's done between the parties. Usually one party gives the other party the wire transfer information that has to be done. Please do not set these courts up for error by having it in your final judgment. Make sure you understand what assets, especially retirement accounts, get divided through normal course versus what needs to be done via quadro. Businesses, obviously very difficult to divide. You guys got to get creative with it. People have different businesses, people have different functions, whether they work in that business together, one person owns it. This is the part that I feel like in South Florida, we definitely have to be very creative on and figure out, but you do need to distribute it. Don't let it be something that's lagging or waiting. So keep that. All right. Some of the other things we're going to consider, I'm just going to kind of just speed through this. Tax consequences, Jackie gave a perfect example, capital gains tax, selling of properties, et cetera. If people are deciding to sell properties, sometimes these activate tax consequences. Most everything has tax consequences. Sometimes there's credits and protections. There's a certain value when you sell a house that you don't have to pay on, but you have to pay on that difference. So if someone's refinancing or deciding to sell the property, keep that in mind when you start to either go through equitable distribution or alimony. The distribution schedule, you should always have one of these that clearly states out who's getting what. It helps the court, I think, clearly see what it is you're trying to have it do, and it helps to make the final judgment a lot clearer. As a practical tip, as I mentioned before, unequal does not mean unfair, but failing to justify unequal equitable distribution will lead to a reverse on appeal. Special considerations, again, I'm just going to speed past this. You guys will be getting your PowerPoint. You guys will have to read the quotes on your own. Marital home, usually the largest asset. You may want to consider this. Sometimes you have temporary division, deferred sales, etc. Consider that. Again, retirement and pension accounts, those are always important. Retirements, pensions are usually important. Military retirements, one thing I want to make clear on that, there is usually something called I forget the name off the top of my head, but there's a benefit that sometimes these pensions have, that despite the person who earned the pensions passing, that division of the property can continue past it. I want to say survivor benefit plan, I believe it's called. So usually for a couple extra dollars, that asset can still be divided even after the fact. That's something to consider having its own value. And if you want the court to determine that, especially in the military, you have to plead for it, so keep that in mind. Just also with retirements, if someone was with a company before they got married and then they got married, you're gonna have to have a quadro expert help divide that, or get an expert of your own in court if you want that somehow being divided a different way in terms of the premarital contributions versus what it grew during the marriage. Business interests are very complicated. Again, you do want to have an expert, be creative, but I definitely strongly suggest trying to settle those issues. Debts and liabilities are also just as important as the assets when you want to consider some of these things. Gift and inheritances, you want to be very clear on it. Make sure you have proper documentation so you're not fighting over silverware that was given during the marriage or at the wedding. And we talk about some examples of when it becomes marital. Temporary relief also is very important. The statute did open up a little bit to allow us to consider more temporary relief options to include partial equitable distributions. We have exclusive use, temporary spousal support, allocation of debt to bills, temporary control of business accounts, and restraining orders against dissipation. Even I mentioned spousal support here. This is important because what's considered for spousal support, especially on a temporary basis, what assets exist. Why does it matter? Depends on who's paying for it. These are all things you want to consider as part of your temporary order. You want to use it to determine who stays in the house, who pays which bills, and to figure out resources that the families need to keep up during the marriage. Statute case law on recent trends. Thanks to HB 521, you can't just say I gave it to them because I love them. Now you need it in writing, preferably notarized. This is important, this change. One, it includes the partial interim equitable distribution. It basically details out how the court can consider it. You definitely want to look at that portion of the statute to make sure you know how to present your case to the court. Interspousal gifts, again, it fixes COP. It's literally, when it's real property, it literally breaks down how you're supposed to divide that and do the math on that. That's very important that you understand it, and very important that you know how to present a case on it, because if the court doesn't have it fully, you're leading the courts to reversible error. Valuation of closely held businesses. This is very important. There's some very new case law that came out on this. If it's not on the slide, you can email me about it. It talks about assets as it relates to multiple businesses of multiple people, to include doctor practices, etc. Those are important case law. There is some separation between the state. Actually, here's the cases here. We'll have them here, look at them. It talks about the valuation of interest in a multi-member medical practice. The other one reinforces the distinction between personal and enterprise goodwill. This is very important when you evaluate businesses. There's a whole slew of case law, but this is some of the more recent ones that came out of the fifth. In Florida, divorce court is not just personal, it's just enterprise goodwill. That's the important division. Those are some other cases here, and the certified question of the Rosenberg. This now, depending on your circuit and district, determines how you're going to decide it now until the Supreme Court gets their hands on it. And this is just a breakout of that same case. The statute Google cited there as well. And that's about it. Thank you very much.
Locations. There's one definition in particular that I want you to be aware of. We'll talk about agreements to relocate, petitions to relocate, some timing issues, the shifting burdens of proof and presumptions that are statutory. We'll talk about the relocation factors. That's it, and then we'll eat. It sounds like a lot, but it'll go very, very fast, I promise you that. That should be very simple. The main point here is that relocations are difficult. In my opinion, they're difficult because it's one of the few winner-take-all type of issues that you present to a court. And similar to cross-border abduction cases, just one person is going to be left behind if the relocation is successful, or one person may lose out on their romance or their job offer if relocation is not granted. So it's high stakes. Your clients are under a lot of stress. And it puts you in a unique position to be able to talk to them and give them really good advice. So in your interview, you're going to be treating this as a very serious case. Dig deep as to the reasons for the relocations. If it's a job offer, for example. I had a case where the other side presented a job offer and attached it to their petition. So before I even answered, I looked up online what this job offer was, what the company was, and it was a completely remote business that sold health insurance. And they really didn't have very big offices, and they told me on the phone when I inquired, yeah, you could work from Miami, not a big deal, you don't have to come all the way out to California. So it requires you to really challenge your clients and dig deep, be generous, come up with solutions for your client to make it beneficial to everybody. For example, some people financially may not be able to exercise time sharing if the child moves. Well, if your client is marrying a very wealthy person, come up with a package maybe that will ameliorate that in some way and make it easier. So maybe they have more time sharing after the relocation than they do now. All right, so we're going to relocate. This is AI, in case anyone thought this was important. So there's a lot of definitions in the statute, but the one I want to concentrate is on what is a relocation. And prior to the 2009 amendments, when we talked about relocations, we were talking about relocation of the child. But after 2009, and I see this even through today, people sometimes confuse that. Really, the relocation statute addresses the situation where a parent is moving their principal residence from where it was after the last order of time sharing or when the case was filed. And so keep that in mind. The other issue that I want to point out is 50 miles. What does that mean when you say 50 miles? Is it driving distance? Is it a straight line test that you might make on a map? And so those are things in the definition that you're going to have to be aware of. And we'll talk about it a little bit later. I'll show you an example. So what if there is no existing order of pending action? You just have a married couple and someone takes the child and relocates. Is that a relocation or not? And we just talked about what happens if it's within 49 miles or over 50 miles, and I'll show you some examples of that. If you're able to get your clients and the other side to agree, your agreement has to show the relocation. Don't hide the fact, be explicit, show exactly what you're doing. You want the details of the agreement. And if there's a pending case, or there was an order from 10 years ago, the court is going to need to ratify your order, so you're going to have to submit it. And you want to do that. And it's not enough that you were successful in getting an agreement. That's hard enough as it is. But you have to make sure that you seal it by submitting it to the court if there is a prior case. Okay, so here's our first case study, and I was alluding to this in the definition section. So the mother moves to Georgia with the children. And by the way, that's not Dade, it's Tbilisi at Hudson. In February, the father files for dissolution of marriage and asks the court to return the children to Florida. Is that a relocation? Mother moves with the children, then father files, so there's no pending action and there was no previous order. Is that a relocation? The answer is no. The statute does not apply because she was already living in Tbilisi when he filed. All right, so despite your efforts, you're not able to get an agreement. You have to file a petition for relocation. Take a breath. Don't use the form. Don't rely on other lawyers. pull out the statute. I'm giving you a very abbreviated section of the statute. Sit, one page, and just like sit and read it and know it. Relocations, and this statute in particular, in our warm, fuzzy, equitable area of family law, where we talk about amorphous terms like best interest, this is one of the few areas in our line of work where the details matter. This is why I always refer to the relocation statute as a technical statute. It literally says this, and I've never seen it in another statute. Failure to comply with these requirements renders the petition legally insufficient. That's pretty harsh language. So there are a lot of musts that have to be in your petition. You can't avoid them. And like I said, substantial compliance. Telling Judge Ruiz-Cohen, no, mostly everything is there. It is legally insufficient. The court cannot grant a relocation. It's over, it's done. And timing can be a big factor. So follow the statute. And the same is true to a certain extent to the objections. Objections to relocation. You have 20 days to respond and file your objection. They have to be verified. They have to include specific factual statements why the court should prohibit relocation. And it also has to say what it is that your objecting client, what kind of relationship and involvement they have with the child. So you have these requirements that you must put in. You can't kind of wing it. You have to take it seriously. Again, don't be fooled by AI. This is not a real picture. You know, in case you hadn't figured that out, I don't know how ChatGPT came up with this picture of the car pushing the house. But I liked it, so I kept it. And I thought, you know, it's very good to know what's AI these days and what's not. But that has nothing to do with relocations. Just, that's kind of a freebie for all of you. Just for taking a case. Timing. So, evidentiary hearing priority. It's what I call a front-loaded case. When you are going to take a relocation case that is going to go to a final hearing, clear your calendar. It's going to interfere with everything because you have to seriously consider a temporary motion. And while it says 30 days for a temporary hearing, you have to actually file your temporary relocation motion. You can't, they don't just award it to you. So you have to file it, and they go quick. 30 days for a temporary hearing, and a temporary hearing on relocation can be pretty extensive, lots of witnesses. And even though at a final hearing, the judge isn't supposed to use the decision to grant or deny relocation as a factor in granting a permanent relocation, it's a real trial, and it's the whole thing. And unless it's a special case, your facts are not going to change that much between the temporary and the permanent hearing. Interestingly, I don't know how, I'm involved in the other side of a petition to relocate where the objecting parties. It was filed almost 2 years ago in July. And no temporary hearing, no final hearing, and nothing was found. So that's probably the outlier. Clear your calendars, prepare to go to trial, start getting your witnesses, think about what your evidence is. All right, here's another case study. And I alluded to this in our definition. What's 50 miles from your principal residence really mean? So, mom and dad divorce here in this building. And then the mother files a petition to relocate to Delray Beach. Delray Beach is literally, if you did what I did, and this is an AI-generated map with a radius circle of 50 miles. I don't know why they put Miami in the middle of the state, but again, it's like the car pushing the house. I thought it was kind of cute, so what do you think? Is this a relocation or not? And I'm going to call it. Okay, I'll just tell you. No, it's not. It's as the crow flies. Meaning, if you were to drive from the courthouse after here and go to Delray Beach for dinner, and you looked at your odometer and it was 52.5 miles. Well, if you drew, and there are a couple of free online websites, mapdevelopers.com, Calc Maps, you could Google them, you'll find them. They will help you pinpoint the address, place your pin, and it'll draw a 50-mile radius circle or whatever circle you want, and show you whether or not the potentially relocating parent, if they're moving within or without that circle. So when it comes to burdens of proof, we have what we call a shifting burden of proof, preponderance of the evidence, and if you as a relocating parent prove that relocation is in the best interest of the child by a preponderance of the evidence, the burden then shifts to the objecting parent who's put in their detailed verified statement in opposition to the relocation, for them to prove by a preponderance of the evidence that relocation is not in the best interest of the child. Interesting thing about presumptions, by the way. Right now we have, in the state of Florida, no presumption either for or against the relocation, even if it impacts your time sharing. You know, you may go from equal or majority time sharing to hardly at all if the child moves to California. But we have no presumptions. But initially that was true. There was a presumption against relocations. And then sometime in the 90s, around the country, there became this freedom of travel movement, and a lot of states came out with cases that said, you are presumptively allowed to relocate, unless the other person proved by preponderance that it's not in the child's best interest. Those days are gone. Now we have no presumption. Instead, we take each case on its merits. Do you think the burden is different if the relocation is international? I say that because we're a funny country. We're a very big country. And if you drew that 50-mile radius from Miami or from Houston or from San Diego, you could capture a lot of countries. And here in Miami, that's a lot of, cities. So do you think that there's a different burden of proof or a different presumption with internationals? And the answer is no, we take every case on its own. But you may want to think about things like, what's the immigration status for the relocating parent, the child, the non-relocating parent? Is the distant country a signatory and treaty partner with the Hague Abduction Convention? So if there's no presumption for or against relocation, how do we establish that relocation is in the best interest of the child? And for that, we have a set of 11 factors. And we'll take them piece by piece, but I'm only going to talk a little bit about each one. So the very first one, probably the most important, is what is the child's relationship with the parents, the one relocating, the one not relocating, and extended family members, step-parents, stepbrothers and sisters. What's their social capital? What is the child's life here? So that's the real meat and bones of a relocation. We also can consider, or at least I should say that the judge must consider, the reasonable preference of the child if they're old enough and mature enough to make good decisions about relocation. And then of course, if you look at factor E, does it enhance the quality of life? What is the family support after relocation or before? Lifestyle changes, costs of living. How is the child's life being enhanced by relocation? Moving down the factors, and you're going to have to address each one. These are required, and you need findings on all of them. What's the reason behind relocation? And what's the reason, what's really happening with the objecting parent asking for a prohibition of relocation. Are they doing it because they want the left behind parents to not timeshare with the child because they really don't like them? And we all, when we dig in our interviews with our clients, you kind of get the sense, you know, they don't want the other party involved in the child's life. Or has the relocating parent met someone and the left behind parent maybe is a little jealous and wants to interfere with the proposed marriage? So you have to find out whether or not these are good faith reasons for relocating and non-relocating. All right, who's up for another case then? So this is another interesting one. The parents and child live in Miami, and then they relocate to St. Pete. And that's St. Petersburg, Russia, not St. Pete. But after they all go and move to St. Pete, the mother and the child return to Miami. And then the court enters a final judgment and establishes a time-sharing schedule between St. Pete and Miami. The father then files a petition to modify it, seeking majority time-sharing with the child in St. Pete. The mother says, that's not a modification of time-sharing. What you have there is a relocation. Is she right? Remember, in 2009, we substantially amended the relocation statute. It used to say, where's the child being relocated to, St. Pete or Miami? It doesn't say that anymore. It says the parent relocating. He's staying in St. Pete. She's staying in Miami. Neither parent is moving their principal residence from the last order establishing a timesharing schedule. So, the last factor is sort of the catch-all, but it also includes a reference to 6113. That's the best interest factors, the 21 factors that we do in all of our time-sharing schedules, all of our parenting plan cases. In fact, anytime there's something involved with the child, what's in the best interest? Well, those are the factors. I'm not going to list them. You know them, sort of, that you have to consider. Now, the judge doesn't have to make a finding addressing each and every factor as it does with your normal time-sharing schedule and your normal parenting plan analysis. But it has to establish that whatever time-sharing post-relocation is in the child's best interest. You know what? This is so new. This requirement that judges be finding the fact that addressing each parenting issue. Let me retract that statement. If you do incorporate 6113 factors as the best interest, why wouldn't you have to address each factor? It's really new. It's not even a year old, and I'm thinking to myself, yeah, you probably should. You probably should, and you have to do findings in a relocation statute. I just haven't seen any cases on that, and all the cases are kind of, they don't even have full citations yet, so anyways, keep your eyes open for that. Know also, relocations do not constitute a substantial change in circumstances to modify timeshare. So just because someone puts in a petition for relocation, you probably, if you're concerned about timesharing, you represent either parent, you may want to file a petition for modification of the timesharing schedule, especially if the court denies it. You can't just modify it. You have to have a reason to modify it. Not even a year ago, well no, I guess a year and a half ago, we modified 6113. We didn't include this in the relocation statute, but if dad, say, in St. Pete, more than 50 miles from Miami, moves back to where the mother and child are living in Miami, and now has relocated less than 50 miles, that is considered a substantial change in circumstance to modify the timeshare. And it's no longer required that you have to establish that that move was unanticipated. You know, whenever you modify timesharing schedule, you have to prove modification, you know, substantial change in circumstances unanticipated. You don't have to do that, that's statutory. But you won't find that relocation issue in 6113.001. That'll be in the traditional 6113 statute. And that's about it. I just want to point out, also, this is AI, don't get excited. I did not ask for a golden retriever. It's kind of scary. AI just thought, you know what would be cute, Ron? A golden retriever. But he made it, he's relocated, okay? And thank you very much.
All right, thank you, Ron Kaufman. That was excellent. The next topic is going to be about digital evidence, technology, and social media. I actually have a phrase that I like to tell people about this topic. Dance like nobody's watching, but email like it might one day be read aloud in a deposition. So these next three speakers are excellent family and matrimonial law speakers, attorneys, and each one of them is fantastic in their own way. Cyril Moody, he actually they're going to be speaking right here in front of us. Cyril Moody, he has studied in many different countries, is my understanding. Jessica Satinoff has represented many famous athletes, correct? Pro athletes. Yeah. And Anya Cintron-Stern has done many litigated trials, correct? Okay. All right. So I turn it over to them, digital evidence, technology, and social media.
How does this work? This was the next slide. Cool. Thanks. All right. Good morning, everybody. Anya, Jessica, and I have done a presentation on this topic recently. I think it was back in November. Because we figured it's a developing issue that we're going to have to address in a lot of our cases, children's issues, discovery issues, and valuations and income sources. And so we think it's a developing topic that we should all be paying attention to. And we'll talk about different ways it affects our cases and how to address it. And let me see if I can figure out how to use this. Yeah, exactly. So we weren't in charge of that part of the technology. Okay, so we want to talk about different types of social media, what purposes they serve, and then really how it affects our cases. So we've got social media platforms, things like Facebook, LinkedIn, Instagram, photo and video sharing apps, YouTube, Snapchat, TikTok. I'm sure a lot of the younger generation is familiar with these, or you have children who use them quite often. Live streaming apps like YouTube Live, Twitch, interactive social media apps, TikTok, another one that's becoming more popular is OnlyFans, which is kind of unique in its own right. and discussion forums like Twitter or X, Reddit, Tumblr, and then you have social shopping networks, things like Etsy, Instagram Shop, or say Cameo, where you pay certain people to do appearances. And so what's important is really to discuss how they affect our cases and how we approach them. I mean, one of the main things are tools for discovery that we talk about. You can take a look at people's social media posts, figure out how to use them, introduce them into evidence. One thing, for example, is take LinkedIn. Think about when someone makes an application for a loan or something like that, they're always going to kind of puff up what their income is, what their earnings are, and what their value is. LinkedIn, you can do that similarly. I'm thinking about using it for purposes like imputation of income to, opposing parties. Information you can provide to a vocational evaluator if necessary, and you can really take a look at that. Things like Instagram, Facebook, you can take a look at lifestyle, spending habits, people posting photos on boats, out and about, partying. So really think about how you can use different social media platforms and how they affect the income streams and all that of your clients. Now, one of the things to be careful is, and we'll discuss it a little bit, client management, about how they use the social media platforms, because it can create certain issues. And let's go to the next slide. So these are just some examples of different types of social media platforms that are out there. We've discussed some of them. Move on. And this is why I think it's really important for us to be aware. I mean, it's a huge booming business, and we'll talk about how, social media platforms can be assets in divorces or sources of income that need evaluation. We got 27 million paid content creators in the US, and 44% say that social media is their full-time job. $26 billion industry in 2023. It's only gonna grow. And so I wanted to talk about monetization. How do our clients monetize their social media accounts? There's types of accounts to consider, say like Instagram versus OnlyFans. OnlyFans, you're kind of selling content. Instagram, you can get a lot of money through sponsorships or selling different products. And then I want to talk, is it an income stream or is it an asset? So for example, let's say a couple's married, they've got a social media page, it's for their pet or for their child who's doing, gift reviews that can be really, really lucrative. How do we go about dividing those? I think it's something that we'll have to address in the future. Then there are also issues of personal goodwill. What if someone's involved in the production aspects of it but isn't the face of it? So there are all kinds of questions that are there. Take a look at the advertising deals that they receive. Take a look at the sponsorship deals that they receive. And then we talk about the income and how it's reported. A lot of people will keep sort of a lot of the income within the platforms themselves, so you're going to have to do some discovery on that before they transfer it into their bank accounts. And that's something to keep in mind. Then let's talk about its role in family law cases. We spoke about it. Discovery tools, pics of lavish lifestyle, LinkedIn possibly for reputation purposes, shows spending habits, uses evidence, sources of income, potential assets, which we'll discuss a little further, and then sharing of accounts, how do we actually go about dividing them? And then let's talk about the children's issues. How comfortable are one parent sharing pictures of the other kids with the other parent, things like that. What kind of agreements should they reach? What if it's being done against consent? And those are all things to discuss and to consider within these programs.
So Zero gave us a whole host of reasons why the information that's uncovered. So let's explore some of those issues in the family law context. And I'm sure that many of you are going to have a whole host of issues that I haven't even considered, because it's going to be specific on your particular family. For instance, information about lifestyle. I know some of the jurors, the judges, and the magistrates here will be so shocked to learn when a party's income substantially decreases during litigation. And what's a way to prove otherwise? Well, if we go on their Instagram and they are in Paris one weekend, or they're taking African safari, or maybe they're in Bariloche, Argentina, going down the slopes, maybe that would tend to show that perhaps there is more income there than what they are reporting in their financial affidavit. Think about supportive relationships. You're representing a former husband who has been busting his ass to make some money to make those alimony payments. And then he hears that his ex-wife, now engaged, has put up a montage of the relationship. It's a beautiful romantic montage, and you see the realtor drop the keys in their hands, and then it shifts over to the next video, and it's the two couples walking into their brand new house. And it's a house that's on the intercoastal, and it's 2-story, and it's gorgeous. Well, that would tend to be supportive of a supportive relationship. So social media can absolutely help your position in court if you're able to know how to use it. And we'll go through how we can authenticate it and get it into evidence in the later slides, but those are just some ideas. Like Cyril said, I'm sure that all of his practitioners have communications with their clients about how they should not be posting during litigation. I'm sure that 70 to 80% of them ignore your advice. So for that 70 to 80% that ignores your advice and decides to post pictures of them binge drinking, or a bachelorette party in Vegas where everybody knows what happens, even though it's supposed to stay there, you can use that evidence to show alcohol abuse, substance abuse, and then hopefully they're a little bit smarter and they're not commenting on how much of a bitch their ex is. But if they so happen to do so and post it, you can maintain that to show history of an abusive relationship. So using these tools would be so helpful. But let's get into how do we safeguard it? Because I'm sure it's not an uncommon practice to, once litigation begins, start going through the social media and posting whatever's not helpful for you, knowing that the other side is going to be going through it at some point. How do we preserve that? And the answer is spoliation. It is a concept that's commonly used in civil court, commonly used in criminal court, and should be commonly used for preserving social media posts here in family court as well. So what do? There are certain things that you can do, like issue a preservation letter. You write a letter to opposing counsel or to the opposing party, and you include very specifically the scope of the discovery that you're trying to preserve, give clear instructions on what's supposed to happen with that. You want to give them a timeline as to how long that lasts, and also clearly identify the consequences you're going to seek if they so happen to continue to delete posts or delete emails. So let me first go into the scope. Scope is, you want to be clear, all emails, social media posts, private messages, direct messages, text communications, WhatsApp messages, be very clear. There are probably so many more of these technological communications that I'm not even aware of. I have to ask my 12-year-old son, or maybe ask Ron Kaufman, who knows more about technology than I do. But you want to be clear in your scope so that you can follow through with any consequences should you have to request the court to issue some. Then let's timeline. You say, the scope of my preservation, I want it from now until the finalization of this case, until the final judgment, until the supplemental final judgment for modification. Be clear about how long this process is going to be. Specific instructions. I guess number one being, cease deleting all posts. Maybe also don't delete any emails, keep your communications intact. You want to be clear as to what it is, so you can say, I put them on notice and it was very clear. And then your conclusion into the consequences. You can say, I'm going to seek legal action, I'm going to seek legal consequences, I'm going to seek attorney's fees and costs, I'm going to seek that you give me your right kidney if you decide that you are going to start deleting your social media posts. And then you want to follow up with a notice of spoliation or a notice of service of a preservation letter, however you decide to title it. There are no clear guidelines on spoliation, so just make it as clear, perhaps show a copy of the letter that was served on the opposing side, and then you want to move forward for a motion for spoliation with the court, so that everybody is reduced to a court order telling them how they are supposed to behave. And as these social media postings become more prevalent and become more of a credible piece of discovery that the jurist will be able to use, as so long as they're admitted, you want to be clear as to what these guidelines are. So I want to say spoliation, just so we have a definition, we are very fortunate that the Florida 3rd District Court of Appeals was the first district court of appeal to issue sanctions for spoliation. So that means Miami is #1 in needing to be given repercussions as to getting rid of evidence. So here, Florida courts have defined spoliation as the destruction or significant and meaningful alteration of evidence, or the failure to preserve evidence in a pending or reasonably foreseeable litigation. We all know that there's so much case law on the breakdown of a dissolution of marriage. So perhaps that could be the starting point of when a party could reasonably foresee when you need to start preserving the evidence. Some consequences that Florida courts have found that they could provide are they could move to dismiss some claims. They can exclude certain witnesses from testifying as an expert. They can even impose legal sanctions. So you want to be able just to set your record so you have that in mind. The other, you see the last one there is Finsta accounts. This is something I had to consult with the Google machine in order to learn, because I don't do this, but Finsta accounts apparently are these fake social media accounts so that you can go in searching. And I see Sandra Sohoyo Mejia. She already knows, because we know sometimes our clients find some very creative ways to get in. But what I want to stress is that for the practitioners, the rules regulating the Florida bar profession have been catching up. And there have actually been at least 3 rules discussing social media and attorneys representing their clients. And basically for us, it's a no-no. Why? Because the litigant or the witness may be represented by counsel, and we are not able to communicate with people who are represented by counsel. Perhaps you can make yourself a witness in the dissolution of marriage or paternity matter, disqualifying you as being an attorney for the party. So these are no-nos. Another rule that the Florida rules regulating Florida bar have discussed is an attorney cannot use social media to inappropriately contact others. So the ethics rules are catching up, and essentially it's not worth it. So if a client comes to you telling you that they've created an account, it's la 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 la, or you're advising them that perhaps it's not such a good idea. Whether they listen to you or not, that's up to them. They could be in that 70-80% who don't listen to legal advice that they pay for. Next slide. So how can you collect evidence in regards to social media postings? One example is you can use an interrogatory. Send an interrogatory to the other side asking for their social media handles, asking for their social media names, and that can give you a good starting place if you're not aware of where they're at in terms of their social media. You can also issue a request for production, but as the case law provides, the request for production must be narrowly tailored. So you can't just go in asking for the whole world. Perhaps you want to learn about travel. So what you do is you have a request for production saying, I want to know of all the postings that you had regarding your travel from January 1st, 2021 to present date. And therefore you got something a little bit more narrowly tailored. It's going to be case specific. So whatever it is that you think is reasonable, is relevant to your case, you can go ahead and request for production that particular issue. But what about the Instagram account or the Facebook account or the LinkedIn is on private mode and it's not public? The Florida courts have already decided that there is no reasonable expectation in regard to a social media account, regardless of whether it is a private or a public account. Now, it's different as to private messages and direct messages, Those are considered to be having more of protections because they're similar to text messages. But your account, you're going to be able to get into it. So caution our clients. We can probably provide them with many examples of how it has affected other dissolution of marriage matters. I'm sure that there are a lot of Google stories out there about how it's ruined some sort of claim as to income or equitable distribution. But these are useful tools for you in order to present your position or your client's position. Next one. So here we have a case. I have many more cases in addition to Nucci that stand for the proposition that there is no reasonable expectation of privacy. So if you'd like to reach out to me, email me, text me, I'll be happy to provide you with additional case law. Now, we can do the next one. Root v. Balfour is just another case that stands for the proposition that social media evidence is absolutely admissible so long as it is relevant. It must be relevant to the issues. You know you want to get in that social media account where your ex looks so, not presentable to try to give the judge a little bit of their character. But it has to be relevant to the particular issues. So relevant to child support, relevant to income, relevant to abuse. Not everything is going to come in. And then it has to also be narrowly tailored. So make sure that you're asking for stuff that are particular to your case. Next one. Now, how is it that you can access some social media postings? Just a question, mostly for my curiosity, and I guess right here too. How many people have successfully subpoenaed a social media company and received a response? Yeah, they're hard. They're hard to get information from because, one, where do you even send the subpoena to? That's, you have to hire somebody just to find where you can send the subpoena to. And on top of that, there is some law, it's the Stored Communications Act, it's SCA, that was enacted by Congress, which generally prohibits service providers from giving contents of electronically stored information to laypersons, and we're considered lay people. Whether or not they provide it to law enforcement is completely different, but we don't have that capability. So if one day you are successful in receiving a subpoena response, I want to know, because I want to know what you did, I want to see your form, and I want to share it with the world, because it is a very difficult thing to do. I mean, most likely you have to do the request for production, or you get the information through other sources, like other witnesses who just happen to be friends with that particular individual. But getting a subpoena is going to be a little hard. The next one. Like Cyril said, regarding social media and the amount of monetization, I mean, I wish that I, in my younger years, had figured out a way how to do that. I have very big feet. I would have made a ton of money on Finder, but I don't know how you're able to get that information now, and other than making sure you get the subpoena, trying to obtain contracts, copies of the contracts that they have with advertisers, contracts for how often they have to post, how much money they've received per each post. And that information is absolutely crucial. Also information on how much money that they're able to garner in a year, because some of these social media accounts can be valued. There is money with them. I've definitely had to do a couple of prenuptial agreements for social media accounts, and we've had to be very clear as to who is going to keep the social media account should there be a divorce in the future. So these are becoming more and more commonplace, so you really want to be able to get a handle so you're not missing anything in terms of income. That's right. I was just talking about Instagram as a microcosm. I will admit right here that Cyril is a person you want to talk to if you want to learn more about how to get information regarding the monetization of Instagram. But I'm sure Facebook has it. There's just so many ways that perhaps hiring a digital forensics expert is the person to go to. They're pricey. Your client has to be able to afford it, but they may be able to pull that information in a much more efficient way than just running around trying to get witnesses to pull posts. We'll do next one. Now the fun part, evidence, and I'm going to speed through this. So like I said, if you have any questions, evidence is what I like to do in my disposable time. It's so much fun. I find it's a way that you really can get a hold of your case. You really have control over what it is that's presented to the court, and it's really a way to get under your opposing counsel's skin if that's your goal as well. So the number one issue is, how do we get it in? And it's provided to us in Florida Statute 90.901, authentication. You have to authenticate the post. You have to show that what it is you're trying to prove is provided and what it is that you're trying to bring into evidence. The best place to look at in terms of evidence and authentication is going to criminal law cases. There's one excellent case, it's Lamb v. State, 246 Southern 3rd 400. It's a 4th DCA case from way back in 2018 when I feel like Facebook had just started. And how they were able to authenticate the evidence is the defendant very smartly decided to commit a robbery and film it and post it on Facebook Live. It posted to his Facebook page approximately 20 minutes after the robbery was committed, and in the video you can see the watch that he had taken from the victim, which the victim was easily able to identify. It was a watch that his grandfather had given him, and the defendant also happened to be wearing the hoodie that got taken from the victim's home. So because of those very particular points, they were able to authenticate the video to show that it was who it was. So I'm sure that you can have so many variations of points that you can use to authenticate to show this is what it's purported to be. Facebook so far has been the only one I've been able to find in terms of the case law. YouTube is also very popular because in terms of the age of technology, it's a very antiquated form of social media, but there are also a lot of cases in which the government was able to identify who was who from the videos as a result of them posting their faces. So again, I hope you have that conversation with your clients, and I hope we're able to reduce that 70 to 80% who's not listening to our advice, and perhaps consider the consequences of what their posts are. Thank you.
So let's talk a little bit about these digital assets in the context of prenups and postnups. If you are not already addressing these assets, you should definitely start doing so, whether these are assets that are already in existence at the time of the prenup or contemplating them being created during the marriage. So you should be including provisions regarding who has ownership of these accounts, meaning is it an individual or is it going to be a joint endeavor between the couple or potentially the whole family if they have children? How income will or won't be shared? So will the income derived from these digital assets be considered marital or non-marital property? And whether the accounts are assets to be distributed. So include a procedure for how the assets will be distributed in the event of divorce and also in the event of death. Will one party automatically be entitled to retain this asset? Does one party have the first right to buy out the other party's interest? These are things to be thinking about. So one prominent example of including these digital assets in a prenup is Vivian Tu. For those of you who don't know her, she is an influencer who created Instagram and TikTok accounts called Your Rich BFF. And she makes content about personal finance targeted to millennials and Gen Z. So she disclosed on one of her social media posts that she herself has a prenup that includes a 100% carve out for Your Rich BFF in the event of divorce. So now we can go to the next slide, please, and talk about sources of income from these digital assets. So one source is a sponsored post, which is when an individual is paid to promote a product or a brand on a specific occasion. So here we have an example of Rihanna. She's posting about Louis Vuitton's leather bag collection. That's one way you can monetize social media. Another way is affiliate marketing. So this occurs when an individual earns commissions from links that they post. And this is common with beauty products, jewelry, household goods. We see influencers posting about them on social media saying, click my link, and if you buy it through there, they receive income through that link. A third source is a brand ambassadorship. So we'll see here, David Beckham has a lifetime endorsement with Adidas, for which he was paid $160 million. And as part of being a brand ambassador, sometimes you need to attend events and post about it on your social media afterwards. And the fourth way we'll talk about monetizing these assets are through account subscriptions. So this allows individuals to monetize social media by providing exclusive content to their followers who pay a monthly subscription fee. So we see this a lot on Instagram, and we also see it on OnlyFans. So we'll expand a little bit more on discovery into these digital assets. So we're thinking about what type of documents to seek. There's obviously the standard tax returns, bank statements. If the assets are owned by entities, you can request GLs, P&Ls, balance sheets, things of that nature. But you can also be thinking about other accounts where these people might be receiving income from the digital assets, such as Venmo accounts. We can also explore issuing subpoenas to third parties, and I'm going to talk a little bit about the information you should be seeking. So one is using a tool called Google Analytics. This helps website and app owners, or in our case, divorce lawyers, understand how users are interacting with these digital assets and the content on those accounts. So Google Analytics can generate reports that has certain information such as page views, session links, bounce rates, which is indicative of people who went to the websites but left before interacting, and also traffic source. So whether the person got to the website through a search engine like Google, or did they click a link from an email that they received. Another source of information directly from a third party is by analyzing advertising revenue directly. So you can get the data directly from the platform on which the person is advertising, and that way that would address any issues of authenticity rather than relying on the party claiming this is my income from this source. Next slide. So some other considerations about sources of income. A lot of times these influencers received gifts or products in connection with their business. So this includes clothing, jewelry, beauty products, and to the extent that these products reduce their personal expenses, you should be thinking about adding them back to that party's income. Another consideration is analyzing whether the party is voluntarily underemploying themselves on social media. So does that party have sudden income deficit syndrome around the time that the divorce was filed? Think about the historical postings. Were they posting 5 times a week before the divorce, and now they're only posting once a week? So the things that we normally look at, but this time just more targeted towards their social media presence. And now that we've talked about the accounts as an income stream, let's talk about them as assets. So we want to think about how to value them. So some metrics that would be specific to digital assets include engagement levels. So we're talking about number of likes, shares, and followers. Also, another metric is audience growth rates. Is it trending upwards or downwards during the divorce? And finally, website traffic. So these are just some additional metrics to be considering when we're trying to put a value on these assets. Another consideration is whether it's an individual versus a family or a couple's account. So how much of it is attributable to enterprise goodwill, which would be marital and subject to equitable distribution, versus how much is attributable to personal goodwill of the individual running the account, which would be excluded from the marital valuation. Also, if it is a family or couple's account, you want to be thinking about the effect the divorce may have on the value of the content. So if it was a family account and now they're separating, the value might be drastically impacted by that. And another consideration here is domain names. And I put that in quotes because it's not really a domain name, but let's say we have an Instagram account with the name watches, for example. That account might have an independent value aside from the specific content that's being posted on the account. So once we've determined the value of the account, We then need to figure out how to distribute it. So as Mark mentioned during his presentation, one factor that a court considers is the contribution of each spouse to the acquisition, enhancement, and production of income. So what if the parties have a joint account or joint channel, like a YouTube channel? So we're asking questions like, which spouse was more instrumental in creating or maintaining the account? Which spouse has the star power that will allow the account to continue being sustained and growing after the divorce? Those are the things that the courts should be taking into consideration when determining which spouse to award a digital account to. Another option, instead of distributing it to one spouse, is to divide certain accounts in kind. So for example, we have here on the screen Kat and Mike Stickler. This couple, they had joint social media accounts, and in their divorce, she got to keep the TikTok, which grew post-divorce, and he got to keep the YouTube channel, which is now defunct. So that goes to show you which spouse was more instrumental in maintaining the account. And we can also do the same, dividing brand partnerships in kind, if that's something that the brands will allow. So, you know, she can keep the Lululemon brand partnership and he can keep the Nike. That's an example. And some other considerations about the accounts as assets. If it is a couple account or a channel, you want to be thinking about how we can preserve the value. Next slide, please. How we can preserve the value while the case is pending. So the value of the asset might decrease if the parties are at odds during a divorce. So disparagement of one party by the other party may negatively impact the value of the account. So, you know, when we think of traditional businesses, if the parties can't effectively run the business, we consider options like appointing a receiver. So that might be an avenue that we want to explore in this context of digital assets as well. And finally, practice tip: when drafting MSAs that have digital assets involved, you should address whether the retaining party may use the name and likeness of the non-retaining party so that you don't run into issues after the divorce. Thank you.
Wrap it up real quickly here. Just talking about, you know, one of the major roles that we play as family law attorneys involves client management. And with social media platforms these days and the impulsivity of our clients, it's really important. So, you know, there are certain things that it's not necessarily we encourage them, but it's fine for our clients to do. So just, you know, share some images of time spent with the family, with kids, but keep it in consideration if you are sharing pictures of your kids, have a conversation, have your client have a conversation with the other side about what's appropriate to share, what isn't. You know, I have some friends, when they post pictures of their kids, they'll blur out their faces or put a little smiley emoji on their faces. So it's something to take into consideration. You know, it's pretty self-explanatory what's seemingly okay. So we'll focus on the don'ts in a second. But one of the things that I want to discuss is, you know, if you've got a client who's impulsive, isn't following your advice, make sure you really sit down and have a conversation with them, or issue like a CYA letter of sorts about the consequences that could arise if they're posting certain things they probably shouldn't be posting. Especially think about and have a conversation with the clients about the effects that probably posting pictures and videos with a new significant other could have on the children. Because at the end of the day, kids these days are using social media more than the adults or the parents are, and they really have access to everything. So it's an effect on them. Next slide. Don'ts. I mean, pretty straightforward on this. Don't share private information regarding your case on social media or advertise it out there, or attack the opposing party's character on social media. Speaking about your judge and complaining about how the case has been handled, definitely a no-no. Don't let your clients do that. Careful sharing, you know, pictures of expensive meals, lavish lifestyle, spending, going on boats. I've had cases in the past that the judge has been completely swayed by the other side just coming in and sharing, you know, a bunch of social media posts saying, look at this lavish lifestyle, evidence, you know, Anya spoke about spoliation and those things. Be careful about that. Careful about posting pictures, alcohol, recreational drug use. Too many people get in serious trouble with that. There was an NFL player who was on a boat just the other day Cardi B's boyfriend, who was out there, and there was a lot that was shared, and he's getting in some trouble with the NFL about that, but it applies to our cases as well. And don't complain, don't let your clients complain about the other side on social media. It's not a good look. It makes the proceedings more contentious. We don't need any of that. Next slide. And, control your client's impulses, but again, always easier said than done, that's for sure. I'm sure we all know. And then we'll end with the last slide, which are children's issues. We touched upon it briefly earlier. There's kind of two aspects about it. It's publishing images or videos of the children over someone else's objection. Really have your clients be careful about that. But then there's another issue that arises in our cases, and what's an age-appropriate time for children to have access to social media or their own platforms, or to set it up. And I suspect we'll be seeing a lot of disagreements about that in the future. I see kids as young as 3 on the phones just going around with no supervision. Whether that applies to social media or not, it is what it is, but really keep that in mind, have your client discuss it with the other side. Think about it when incorporating certain parenting plans or agreements. And like we said earlier, it's a developing field. I'm sure we'll be hearing there'll be more issues that arise with this in the future, but we wanted to give everyone an idea of certain topics out there and what to be thinking about. And with that, we conclude our presentation. Thank you, Brittany.